Mr. Collier is going to lead us in prayer.
Okay. Thank you, Chairman Butler. Am I on here?
Yes.
Thank you so much. I appreciate that. Thank you. Thanks for all can hear. If you can bow our heads, please. Thank you, Father God, for this opportunity to assemble before you today. We thank you for blessing us with ears and senses to listen, which is first and foremost very important to listen and to use to the best of our abilities to review the cases and those who come before us. We appreciate this opportunity to serve on behalf of the department and on behalf of the state of Texas and on behalf of representing the licensees and taking care of the citizens of this state, which is first and foremost. We also want to ask, dear Father God, for your covering and for blessing those with safety and health for those in the Deer Park area. Commissioner Butler, who's not here today, is in Deer Park and represents that particular area, and want to ask for your covering and good health for Commissioner Butler and his family in the area and for the licensees that serve. Bless us as we do your will today, Father, in your name. Jesus, I appreciate it.
All right, I'm going to call the meeting to order. Time is 8:30 on the nose. Got to like that. Chairman Mike is not skinnier or better looking. No, he's a new chairman, so just to let you know. I know he's listening, so for the record. Rick Figueroa, I'm glad you guys are here. I appreciate the commission. I'm excited about what we have in front of us, and so I want to get started. Tamla, can you call roll, please?
Chairman Figueroa,
Here.
Commissioner Butler, Commissioner Callis, Commissioner Collier,
Here.
Commissioner Garza,
Here.
Commissioner Weston,
Here.
Commissioner Yurko.
Here.
Okay, thank you very much. Okay, we're going to start with public comments. If there's anyone wishing to address the commission on a matter that is not on the agenda, so specifically not on the agenda, if you're here to contest a case or a rule, we'll call you up when you get on that agenda item. If you want to speak, please fill out a public comment form and turn to Ms. Fletcher, and we'll start off there.
Mr. Chairman?
Yes, sir.
If we could, first of all, welcome aboard and taking the helm. And as is my job, it's to correct you when you make your first error. And your first error is accepting maybe a motion for excusing the absence of Commissioner Butler and Commissioner Callis.
Absolutely. I need a motion for Commissioner Callis.
So moved.
Second.
All in favor?
Aye.
Opposed? Motion passes.
Thank you, sir. Appreciate you.
Thank you very much. Hey, I like it already. I like it already. Yeah, I'm gonna go ahead and go. You okay with that?
Yes, sir.
All right.
I'm good. I'm good.
All right. All right. Public comments. First person is Donald Zimmerman.
Come up front or
Yes, come on up front, sir. Yes. You have 3 minutes. Commissioners, we won't ask questions. You just be able to hear. So just
I'm actually,
go ahead and have a seat and state
Have a
your name.
seat?
Yes, sir.
Oh, okay.
Have a seat and state your name into the microphone, please.
I'm Don Zimmerman with Home Elevator of Texas and a national organization called AMA. And I'm here well, actually, our state elevator inspector, Jim Renane, and the deputy made a comment that we needed to come to this meeting because House Bill 2466, that requires certification of our elevator mechanics, I own an elevator business, is going to, there's a House bill, if it turns into law, it's going to go into effect on January 1st. And so this is the first time this kind of thing's happened in the elevator industry as far as a House bill going into law that requires certification of mechanics in the state of Texas. And so we want to make sure, as I read through the House bill, I didn't have any, it's a good idea, but what it was asking for is that the education and apprenticeship programs for the elevator industry be decided later on by the administrative rules. And I think we need to, in my opinion, from the experience I've seen in other states that have passed this into law, that we need to address if this thing does pass into law. First of all, I'm not sure of the procedure, and I might need some clarification on how it goes after this meeting. But we want to make sure that the actual education and apprentice programs that are going to be required if this bill passes into law are actually written into the House bill and the law instead of decided later. Because if it does pass into law, some of us have certifications from NAEC's CAT and CET program, and then there's union companies that have certifications from the union program. And we want to make sure that those programs are written into the law so that we know if it passes, we're certified. We don't want to catch ourselves on January 1st not being certified because the program wasn't approved into the law. So that was really my main comment to put on record. Because this is the first time, I'm a little bit ignorant as to how this proceeds from here, this House bill, and I need to, I'm learning fast, so if you have any comments on how that works, I'd sure love to hear it, so.
Okay, well, I appreciate your time. We can't ask questions in this portion as a commission, but if there's any just general comments the commission would like to make?
Yes, Chairman, I think one of the questions that we can answer is, we'll be available at the meeting, staff will, and we'll
Then
convene.
we can talk to you, that'll be
Yeah,
great.
we'll convene and just kind of
Okay.
walk you through the issues. Yeah. Okay,
Fantastic.
absolutely, looking forward to it.
Okay, thank you, folks.
All right, Felipe Sandoval? You can just state your name and then the microphone, please.
Good morning. My name is Felix Sandoval. I'm from McAllen, Texas. I would like to approach the commission and I have a handout that if I could have permission to distribute it, and then I'll get into my public talking. Can I do that? Can I give a handout?
Yes.
Yeah, Brad said yes.
Oh, all right. Good morning, Mr. Figueroa. I have a handout that I would like to distribute to the commissioners, if I can. No, it's different.
Go ahead.
Okay. I'm here today as a advocate of public awareness on an electrician's issue. The handout that I have given out to the commissioners is basically the electricians right now are getting their licensed requiring so many hours to take a journeyman's exam and a master's electrician's exam. However, I've also been to the December 4th advisory board meetings, and I know that I have to follow certain procedures, as the gentleman before me had mentioned before, and I'm here also to get my to self-educate myself on the procedures as how things work and so forth with administrative rules and things like that. So it's my second time here in Austin from McAllen, Texas, and I'm also looking forward to doing that. But I would like to introduce a vision that I've had, plus vision/idea about electricians right now. We know that there's a shortage of electricians in the state of Texas and also in the United States. And my idea is, if with your permission, if I can read it off the paper that I brought. My idea would be to grant a 1 year towards a journeyman's exam to students who graduate with an associate's degree from an electrical title from the Texas Higher Education Coordinating Board, and I have been a member of that board before in a program of study for electrical courses. This degree should come, of course, from an accredited college. As we know, and as I mentioned before about the shortage of electricians that we have, again, not only in Texas, but in the United States. And the electrical industry, I have learned through some years of experience that they are actually requiring new employees to be trained before they come into the electrical jobs. For example, an electrical contractor doesn't want to hire people just off the street now. They want electricians who have been trained or have received some kind of training. In this case, it'll be a certification or maybe even an associate's degree. So with that in mind, I have developed a scenario that I would like to introduce not only to the advisory board that I did back in December, but to this commission also. And the scenario, as I have written in this handout, is that students that would be even in high school, we will start training them in the junior year. A student in the junior year of high school can begin taking courses as a dual enrollment student. Of course, we have dual enrollment all over the place with other courses and other programs and other careers. So now we are introducing it as a technical programs. So when the student, he or she may graduate from high school as a senior, they will hold a certificate as an electrician apprentice or as and continue into a community college
Mr. Chairman.
and obtain an associate's degree.
We were up to time, so.
Okay.
Right.
Anything,
Right.
closing sentence, if you'd like any.
Okay. Yes, I would just like to say that technology is taking a very fast pace in our society, and we have a plan, or we should have a plan to meet it at least, or at least stay in focus with the changes that it brings.
Mr. Sandoval, I appreciate your passion on this.
All right.
This is exciting, and I appreciate you taking a proactive stance. I
Okay.
can't tell you enough. Thank you.
Thank you
Is there
very
any
much.
comments?
All right,
Thank you very much. Mr. Charles Herrera. You got 3 minutes, and just state your name in the microphone. Yes.
Good morning. My name is Charles Herrera. I am here to talk about HB 2466, the licensing of elevators. I'm going to echo a little bit of Mr. Zimmerman's sentiment, but I've been in the industry since 1997, and I am one of the directors for EMR Elevator. We're a non-union independent elevator company, and we have offices throughout the entire state and all the metroplexes. My major concern about this bill is that the rush of this bill, it didn't seem like there was any input from any contractors that I'm aware of, unless it was all signatory and unionized, which I'm a little concerned about as well, because once our certified technicians get on a register on a public register, now it's easy pickings to try to organize our company. Also, the CET program is what we utilize. It's a 4-year program. It's administered through the National Association of Elevator Contractors. I am one of the instructors, and this program has been around since 2001. The NAAC has been around since 1950, all developed by veterans of the industry. So it absolutely needs to be in this bill if this bill is going to move forward. The other concern I have is, I'm sorry, lost my train of thought. If this is about a safety issue, I'm wondering why we can't put more, or why can't we put tighter restrictions on the contractor's license instead of putting on public display all of the workers in the industry where they could be liable, or they could, incidents or accidents, they occur, and that should be on the licensed contractor. When we have a public registry of licensed contractors, that tends to put a lot more eyes on the small guy and put a lot of liability on him. So I have major concerns with that. But this bill altogether, my previous job, I was a national service manager, so I got to be in many states that had registration incorporated with their licensing and regulations of elevators. I understand that Texas is probably on an inevitable path for that, but I would like to be able to have non-union contractors submit their ideas to this bill before it's submitted. The timeline, it's going to be enacted by September 1 of this year, and then 4 months later, contractors are expected to be compliant. That's not a realistic timeline for most contractors, and I think that it would put a lot of people out of business. So that's my opinion about that bill. That's all I got.
Sure, thank you for your passion for
Thank
your
you.
industry. Appreciate that.
Yeah. Yeah, thanks, Charles, for the insight as well. Appreciate that.
All right, Mr. Nelson Belisheen, am I getting that right? Is that close enough? And I guess Miranda Slitter? All right, I'm getting there, man. Brian, you should work on me.
Sir. Working on the
3
phonetics.
minutes. Speak in the mic, just state your name if you don't mind.
My name's Nelson Bellisheim. I'm with Otis Elevator out of Houston, Texas.
Miranda Slider with Otis Elevator in San Antonio.
So we're not here to talk about licensing. It's not our jurisdiction, but we do want to talk about access to public elevator records, which has pretty much stopped for owners and elevator companies in the state of Texas. If you go on the website to download copies of inspection reports, which are very important to us, it says the TDLR public webpage for viewing elevator documents is temporarily unavailable, and owners and others, I guess contractors, can go to open records and get that, which is a long delay. So we want to talk to the commission about what's in it for the companies, everybody in this room, actually, it's an elevator company, and what's in it for the state of Texas. So, Miranda?
So what's in it for our company? We use it as a marketing tool. So we can pull up the reports and we can see what type of elevator is at that certain building. And so that helps us know if we can basically take care of the elevator or not. That's one thing. The other thing is we can see the violations that they've had over the past years. If we can't pull up the records, or if we don't get them in, a good amount of time, then we're not able to help the customer get those violations taken care of, which they only have 30 days to get taken care of. So that'll help the owners of the building as well as us to get the violations done quickly. It also helps with planning to get the inspections done in a timely manner the month that it's due or the quarter that it's due. So that helps us, the customer, with that as well. And then just knowing the history of the building, past violations, things of that nature. And then lastly, knowing the new codes that come through.
So what's in it for the state of Texas? Number one, from a safety standpoint, for sure, the biggest thing is that the owners and the elevator companies can resolve violations a lot quicker if we have access to the records. When an elevator is inspected, we don't get a copy of that per se at the time. Sometimes the inspectors don't even share what they saw while we're performing these tests that are witnessed by these inspectors. We have to depend on going to the state website sometimes to get that information. Owners of properties can also do that. They have issues of their own they have to resolve. If they change ownership in a building, they don't know what the past history of that building is, unless they can go on the website and look, and they don't have that access right now. If you lose your certificate or if it's stolen off the elevator wall, you can download a copy of it. Not anymore, until we reinstate it. When we apply for permit applications for alterations, there's a lot of information on those reports, on the inspection reports, that we pull off to apply for permits with the state, so. I guess our 3 minutes is close to being up, but in conclusion, we would like to ask you guys, or the commission, to please maybe make a new decision to reinstate the public access to elevator records online for elevator companies, owners, and interested parties. Thank you.
Nelson, Miranda, thank you, guys. That's some good information to know. I appreciate your time. Just to get them down here.
Mr. Chairman, this is Brian. I think we'll be available to meet some folks after this meeting as well.
Absolutely. Especially on the elevator issue, I'm almost repeat myself on this thing, but Brian is very excited to meet with you guys on this, and so your input is very valuable. I realize the constraints that we have to operate in the open meetings, but Brian, to talk about directly, we want to hear your comments, and your input is invaluable to us.
Yep.
Jackie Herrera.
Hello, I'm Jackie Herrera. I represent EMR Elevator, an independent elevator company contractor. I'm here to talk about the removal of access of online records as well. We have also been inconvenienced as a contractor We utilize the information to take care of the elevators that we're responsible for. The information is very valuable when we are taking over a contract. When we have the elevators, we want to know the information. We want to know the plan reviews. We want to know the violations. We have to have the information in order to assess the condition of the elevator, the alterations, the previous conditions are very important when we have them under contract. And it's important as contractors to be able to have that information at hand always. And right now, with having the removal of the information, it's very inconveniencing to have to go and wait 24 hours and ask for information and then get one piece of information at a time, one report at a time. It was easy to be able to go in and be able to locate whatever plan review you needed. And I think as a contractor, we should be able to have that information accessible to us at all times since we're responsible for the condition. The elevators are, they're for the general public. So since we are taking care of the elevators, I just feel like we should have the responsibility of being able to go in and access this. So I'm asking to reinstate the access to the public records for the plan reviews and for the inspection reports again, please.
Thank you, Ms. Herrera. Again, thank you so much.
Thank you.
Yeah, thanks, Mr. Herrera.
We're gonna
Appreciate
need-
that as well.
Thank you.
Yeah.
All right, Madeline Rogers. Oh, sure. Dan Manor? Bueno.
Good morning. My name is Dan Monroe. Thank you for saying me. I'm from LaPorte, Texas. I have
I'm sorry, can you repeat your name, sir?
Dan Monroe.
Thank you, Dan.
Okay. I have applied for a mold consultant license. The application is in. My problem is that my experience is being denied. Okay. I have over 10 years with my last employer. Statement from that employer says that I do perform building maintenance tasks. The definitions, right? I'm sorry. The Mold Assessors Remediators Administrative Code. Okay. Section 7852 dictates the number of years of experience in an allied field. 7810 defines allied field and building sciences. All right, I'll just read the definitions really quick. All right, molds, or for allied field, mold assessment, mold remediation, and any field whose principles and practices applicable to mold assessment or mold remediation, including, let's see, asbestos abatement, lead abatement, industrial hygiene, building sciences, public health, and environmental remediation. Now, under building sciences, says the field of study covering the design, construction, management, and performance of building systems, including structures, enclosures, and electrical, mechanical systems, environmental systems such as temperature and moisture control, safety systems such as fire suppression alarms, lighting, acoustics, diagnostics, or diagnosis and correction of problems with building systems. Having over 30 years as an electrical technician, working on, for various employers. This last one was with Praxair. Again, I've got a statement from them saying I do building maintenance tasks. It's not in my job description, but it's there. And she says, no, you're working industrial. Well, the person who I spoke to, don't have the name, said, no, it doesn't count because it's industrial. It doesn't count because how does electrical systems apply to, the principles of mold assessment, mold remediation? It's in the rules. It says, yes, lighting and acoustics, nothing to do with mold. Absolutely nothing. You don't need light for mold to grow or dark. But it's there. Acoustics, likewise. I'm looking for you guys to look at the rule and make a judgment to say, yes, I can take the exam. That's all I want. That's it.
Thank you, Mr. Monroe. Appreciate it. Thank
Thank
you
you.
so much.
Yep, thanks.
Ms. Scruggs.
Sure.
Just, you guys have a seat, just state your name.
And we both have
Sure.
papers there we'd like to do.
Well,
this.
she can only comment, she only filled it out.
No, I filled out one also,
What's your name?
Marty.
Marty?
Yeah.
We own the same
We
company.
own the salon.
Okay, there you go. Thank you.
Yes, my name's Thelma and this is Marty Scruggs. We own Hair Tech.
In Houston. And we've come to you to talk to you about a few issues that we're facing. We opened up our salon right at 2 years ago. And we've run into some issues that we didn't think we were going to have. And part of it is due to changes that have been made in the regulations, and part of it is due to regulations that are not necessarily being enforced. When my wife was here last time, one of the things that she mentioned was underground work, or people that are doing work out of their homes, their kitchens. We've been on Facebook. We know some of the people personally that are doing this. We feel like it's dangerous. And with the information that's being posted on Facebook and other places about the deregulation, we feel like it's going to get worse, and it's going to affect people's health. It's going to affect sanitation. It's going to make it where it puts people's their lives or their health at risk from either being burned, catching a disease where the implements are not sanitized properly. But it hurts us in that we have a difficult time trying to find good quality licensed hairdressers, because they're going to the schools, they're learning what they think they need to know, and a lot of them have been doing hair already, and they just take what they think they need to know, and they're not paying taxes, they're not paying payroll tax, they're not providing proper insurance. And it really concerns us as salon owners that we've had people that have come in, that have gone to these places, and that, one, they want a friend discount, but the other thing is they're coming in with hair that has been damaged so bad because they're not following proper procedures, and it's a real concern for us. And then when I see that there's a bill that's before the state house or the state Congress of deregulating the barbers and cosmetology, that really concerns me even more, because our stylists put their hands on people. And there's not a lot of industries where they do that, and if there's not some type of oversight, we have real concerns about the type of work that's going to be done, the abuses that are going to happen because of that. And we felt it was important enough. I have a full-time job outside of the salon. My wife runs it. And I felt it was important enough to take a day of vacation to come up here and talk about this. What do you want to add?
Mostly that I do get stylists that'll come to me and they'll want a job because, they are tired of that situation of working from the kitchen. And when we went to beauty school, I'm in the industry now for 32 years, and I have 4 different state licenses behind me. Texas is actually behind the wheel on this situation. When I lived in Oregon, that's all they had was a booth rent situation. Now we have this situation where everybody's blowing up these suites, and that's all great. Well, when they can't make it any suites anymore, and they have this clientele, this small clientele that they've gotten, they don't want to go back to structured hours and working in a salon such as mine. That's when they take it underground. Taking it underground is what's causing the problems. Now that they have Facebook, they have these, all these ways that they can advertise and those sort of things, is causing the biggest problem. So when I was in Oregon, That was the one thing that I had to address. I was like, I don't know anybody in this town. I don't know what I'm gonna do. How am I gonna make a living? To do what I normally do. So I went ahead and I took a chance. But the one thing that was required of me was I had to name the place where I worked. I had to give the license number to the place where I worked, an address, and a phone number. If you can't provide that information, then how do you get a renewal?
And Ms. Scruggs, I think we're about out of time, but I can't tell you, I know you took a day off. I appreciate your passion for this industry, and it's because you guys are passionate that we can do our job. So communication to enforcement is always important when you see this, because we're concerned about that. But thank you for your time.
Yeah.
You're welcome.
Yeah, also appreciate your time as well, and thanks for the ideas too.
Yes.
Thank you.
The last time I was here and I had spoke to you about it, Ms. Helen, and you told me, you said that if I can show pictures of that, then that would matter too. And I do have those pictures on my phone. I have where the suites are asking like for 4 months free rent because they can't get, stylists in there now.
Yeah, so your 3 minutes is up. If you
Yes.
can just connect with staff
Will do.
before leaving out tonight.
And Brian, we'll be happy to, we'll get that, if you submit that, especially to enforce. Thank you.
Yes, sir.
Mary Littlefield?
Good morning. I'm Mary Littlefield Devine. I'm a licensed midwife, certified professional midwife. I'm also a patient safety advocate and an ethics mentor. I've come in today to give public comment against the revised Rule 115.1156, labor and delivery. I have significant concerns about the effectiveness in the way this rule has been written. The rule states that in an emergency during labor, which implies an out-of-hospital setting based on the licensure of the midwives this regulates, that an emergency exists with abnormal fetal or uterine monitoring, which includes bradycardia, tachycardia, persistent decelerations despite position change, and tachysystole. The way this rule is written, it is too vague and it will be difficult for TDLR to enforce because some of these findings are not actually emergent findings based on the national nomenclature for fetal assessment. Some of these findings can actually be considered normal findings. Some of them may need further assessment or intervention, but do not constitute an emergency under, again, the national guidelines for fetal assessment. Some have spoken against the effectiveness of fetal monitoring out of hospital and expressed concerns about the limitations of what we can actually hear and assess with the tools that we have. There have been no randomized controlled studies that have shown that the intermittent auscultation that midwives are applying and interpreting out of hospital has any different outcome in terms of being able to predict or prevent the types of outcomes that external fetal monitoring in the hospital is thought to be able to avoid. So there have been no changes in long-term outcomes for newborns anywhere in the world using external fetal monitoring versus using the intermittent auscultation that midwives in Texas are trained to use. Leaving this language vague increases the risk of ethical blindness in that the types of outcomes that these violations typically address are typically unforeseeable and catastrophic. Oftentimes, it generates fear in those who are hearing the case and those who are defending the case, and that fear component, again, increases the risk that things will not be seen in a clear and scientific, factual manner. The American Academy of Pediatrics has stated that while there will always be expert witnesses who will opine that if a baby had been delivered sooner, that a particular neurologic outcome could have been avoided, but there's no scientific basis for that. Unfortunately, a minimum amount of research was done on this subject for decades because traditionally the provider was simply blamed. And we now know that there is more behind it, that we cannot assess fetal status through the heart, that the majority of the time when there are not other catastrophic events occurring in labor, there's a pre-existing insult to the newborn's or fetus's brain that cannot be detected by any form of fetal monitoring. So I ask that you review the language to make it more clear. As it is written, it implies that all tachycardia, all bradycardia, and all persistent decelerations, despite position change, constitute emergencies. Under the national nomenclature, that is not true, and this could become problematic. Thank you.
So thank you, Ms. Littlefield. I want to remind the commission, we're going to be talking about this later on the agenda. So But thank you for your time.
Thank you.
so much. Ms. Hughes, Mr. Hughes.
Good morning. My name is Nadia Hughes, and I am representing hundreds or thousands of stylists across Texas, and also my community, myself, and Trichologists on a Mission, which are stylists that we're not only licensed, but we went far and beyond to study the scalp disorders, the hair and scalp disorders, and this is the issues that we're seeing when it comes to barbering and styling, and this is what we want to be able to stop when it comes regulation. You know, so on my end, I want to ask to keep the licensing because our communities are at stake when it comes to safety issues from all this disease that we treat. I personally treat people with this type of problems. Not only that, but I went far and beyond to become a research assistant with the state of the University of Chicago, Illinois, to be able to do research on scarring alopecia, as there is not much research when it comes to scarring alopecia in African American women when it comes to CCCA. And I believe that was our main case. But also, we are the front line when it comes to with dermatologists, okay? We're the first ones to get to see the problems when it comes to hair loss, scalp disease, and things like that. So dermatologists, it has taken us a lot of time to be able to earn respect from dermatologists, to pay attention of the things that we present to them when it comes to that, because the fact that we're the first ones in the front line, like I said. So it is important for me and for others and for my community and for my colleagues that were here earlier to keep the regulation and licensing. We want to be able to do things by the book, and I think many will be affected with this. This is, go ahead.
Well, Ms. Hughes, she didn't.
She is here.
What's her name?
My name is April Kearney. I've also signed a document requesting that I be able to speak. So if this is the proper
Sure,
time.
that'd be great. Go ahead.
Thank you. Again, my name is April Kearney. I'm the owner of Bling Hair Salon and Restoration and Revival Systems here in Pflugerville. And I have been a licensed cosmetologist for 25 years. I benefited from by becoming a licensed cosmetologist through a vocational education program at high school. And so I do understand somewhat of both sides. I'm here to voice my opinion and concern to vote against the House Bill 1705. The licensing and regulation of our industry is of the utmost importance. It's more than just styling hair. We deal with the health on the inside and the outside. We see women and men with hair loss and scalp disorders, and they basically come in, the majority of them, 89%, come in from poor practices. What is taught in cosmetology school is the foundation of sanitation. It's the foundation of hair and scalp disorders. The skill of trichology, which is the hair and study of the science and hair and scalp disorders, is a very, very important part. And I know that people feel like 1,500 hours is excessive, but it actually requires more than that. If there's anything on the table that needs to be changed, it's possibly the process of the licensing to allow for independent contractors to have a mandated time to come in and practice underneath skilled professionals that have more experience in the industry, that have also partnered with endocrinologists, dermatologists, and trichologists. That is all underneath the umbrella of cosmetology. So the deregulation of this licensing is of the most importance to put on this table so that we say no for the deregulation, and we actually go in, enforce more regulation for sanitation. That is our main concern. The styling part has everything to do with the sanitation piece. We see hair and scalp disorders, disease of the skin, and these are life affecting issues. And so those of you all who do not understand the depths of cosmetology, please be informed, please get educated, and please do not deregulate this license. It is very important that our young aspiring stylists understand that it is a combination of science as well as style. It's not just a trend. It's not just a YouTube. It's not just something that's faddish to look like a celebrity. There are celebrities that are also suffering with this hair and scalp disorder of alopecia and CCCA, just as Nadia mentioned. And we are the ones that are here to fix it. If you all deregulate having a license for cosmetology, it's actually going to give us more business as licensed cosmetologists. But that's not the way that we want business. We don't want people suffering and having to be forced to come and see us. We want to make sure that those that are young, those that have a desire and a ministry to help and heal, have the proper regulation, have the proper sanitation, and have the proper practices so that they can go in and do these practices the right way, and so that we don't affect the health of other people. So
Truly
thank you for your
appreciate
time.
points,
Thank
Mr.
you so
Chairman.
much. I appreciate your time on this. Thank you so much, lady.
Yeah, thank you.
Unrelated to theirs, so I'm not commenting on their comments since we're not supposed to, but I do want to give a shout out to hairdressers who do have repeat clients who are able to catch signs such as cancer that often does happen in the skin, which is under your hair. And if you don't have a repeat stylist, they're the ones who are on that first line that see that.
Yes.
That's often people don't catch. And
Yes.
Thanks to them.
Yeah,
Thank
and
you.
I appreciate your comments as well. I mean, that's one of the reasons why, since I've been on the commission, that I've gone out to the shops so I can hear, grassroots as to what's transpiring, as well as going to the colleges and so forth. So, so thanks for being here. Nadia, is it Nadia?
Yes.
Thank you, and I know April Berling, so thank you, Ms. Berling, so thank you.
Yes, thank you all so much.
Yep.
Thank you.
Mr. Chairman, Brian Francis, if I could add one thing, though. Keep in mind that the bills that are being talked about,
Right.
that's outside of this commission's purview. They have no authority over the bills. That's over the legislature. Go back to conjunction junction, what's your function, I'm just a bill. That's over at the Capitol, but I think it's important for the commission to hear your concerns. But the hot seat of whether they deregulate, they don't have the authority to deregulate or not. So it's important to hear what you say, but this is not the venue that they would make that decision. That's going to happen at the Capitol, and I think you're aware of that, with your legislators and that sort of thing. But I think it's really valuable information for the commission to hear. I just want to take them off the hot seat of they're not going to deregulate or not. They're going to do what
The seat's
law
not hot,
tells them.
Brian. The seat's not hot.
The seat's
Brian.
not hot. Outstanding.
It's a little
Outstanding.
warm, I'm not gonna lie. It's a little warm.
Outstanding.
Let's go with, I'm gonna go to Mr. Lord, Mike Lord. Here. All right. Going once? Okay, there you go.
You.
Mike Lord, yes.
How are y'all today?
Good. Mr. Lord, you got 3 minutes, and just state your name in the mic if you don't mind, please.
Thank you for taking the time to hear what I have to say.
Yes, sir.
25 years ago, I started in the elevator industry sweeping floors. Whenever they put you on a service route, you had 60 to 70, maybe 80 elevators.
Could you say your name?
State your name again in the mic. State your name in the mic.
Mike Lord.
For the record.
Mike Lord.
Okay, go ahead.
And today, they put about 300 units on one guy. The big companies do. Individual licensing is a mistake, because what you're going to do is you're going to limit the manpower more. We have a very hard time hiring people now. When you increase this requirement, you have less experience. The older guys that are already tired of it because they keep piling more on them, they're going to go to retirement. So these problems we're having with drum brakes, various safety issues that are getting people killed, the people that really know how to deal with the older equipment, you're driving them out the door. You're not making the system safer, you're making it more dangerous. Before regulation, 65 people a year were killed on elevators nationwide. Today, with all the regulation we have, that number has not improved. It's only gotten worse, if anything. So, in my view, to pass this law, you're putting the companies in a position to be able to pass the buck off to the guy in the field, put together a blame game, take out small independent contractors, something that we've worked a lifetime for. And there's just no point in doing this. It's not going to improve one single thing, and I strongly oppose this legislation that's been put before for vote. Thank you for hearing me.
Mr. Lord, I tell you again, much to conjunction junction function over there. This is a legislative issue. This is a legislative issue.
Correct.
Right? So I encourage you to contact your legislatures. We're not on that side, but I love your information, and we want to hear from you. But again, and if you need help on that, we would be happy to let you contact the legislators that are key to those issues, okay?
Perfect. Thank you.
Thank you, Mr. Lord. Thank you for your time. Thank you for your work.
Likewise.
Thank you.
Ms. Jennifer Keller?
Good morning.
Hi.
Morning.
I'm Jennifer Kelleher. I'm a licensed midwife and certified professional midwife. This morning, my comment is just that, just a comment. There has been much discussion and confusion and
One
an
speak to the mic.
absence of information in regards to expert witness review of the complaint submission for licensed midwives in Texas. And through that discussion, there's been lots of questions in regards to what that process looks like, how expert witnesses are vetted, whether their credentials, are they educated in rules and laws that we are required to abide by. And really, I think what we are seeking is accessible information in regards to what that process is, what complaints actually are assigned to an expert witness, how does that apply, how is that information applied to the complaint as decisions are made. And that is my primary concern, and I think that that's been a problem in the past and something that we would all like to see resolved, I'm sure, and what we can do to help that process run smoother. Thank you.
Thank you.
Thank you so much. Edgar Armando? Edgar? Here?
Say it again, Mr. Chairman.
Edgar Armando? You're up, sir. Good timing. Good timing. All right. Do me a favor. Pull the mic to you. State your name, and you'll have 3 minutes, okay?
Okay. My name is Edgar Argumedo. I'm a barber here in Austin, Texas. I just wanted to add to the people that just talked and about the HB 1705. I'm a barber and I use a razor when I do a neck shave. And I think all the barbers in Texas do it too. And that is something that we need to take care of our community. And abolishing and taking off the licenses from barbers is actually something that we cannot have. One, because in school we learn the safety to take care of people in our barbershops and in cosmetology salons. And I just wanted to add that I know that you guys don't have control over passing or canceling or whatever with the bills, but it's good that you guys know and understand that we are here to take care of our community and be safe and be clean and not pass over any diseases and stuff like that. And I just wanted to add that.
Thank you so much.
Okay, super.
Thank you so much for
Thank
your.
you.
Okay, I think I equally butchered a lot of y'all's names, but a lot of y'all's penmanship could be desired, I'm just gonna tell you. But I appreciate the effort. I don't think, Tamala, is there any other forms that I'm missing here? I think I got it. Okay, we're gonna adjourn into executive session to consult with our attorney under section 5. One more? Well, then, we're gonna hold off on that. Stand by. Mr. Epstein. Ms. Epstein, yeah, sorry. I'm consistent, if nothing else.
Good morning, Commissioners. I'm Brielle Epstein. I am a licensed midwife and a certified professional midwife, and today I am here representing the Association of Texas Midwives, which is the professional association for licensed midwives. We do also have nurse midwife members. We represent over 200 midwives in the state, close to 220 right now. We are excited to move forward with our proposed rules revision. An important goal of our professional association is to help our profession learn and change and grow. And we feel that these rules do just that. We are committed to high quality care with excellent outcomes. This often means having hard conversations, sometimes about the things we're doing wrong or could improve on, and sometimes about the ways that we're thriving and providing great client care. In these rules, we have pieces like the post-dates rule, which simply clarifies a confusing rule. There's what we're calling the transport refusal rule, which helps when a client wants to exercise their autonomy, but it conflicts with the midwife's clinical advice. And so it protects us in that situation where we don't have to continue providing care in a situation we find unsafe. And these are, pretty great gains, both for us and for the consumers who use our services. You've already heard on the fetal heart tone rule, ATM supports this rule. We believe it removes some ambiguity that was in the previous rules, which kind of just said if the fetal heart tones are abnormal, you have to go in. And what we found was that it was sometimes hard for midwives to assess what does abnormal mean. Some of us who have, been doing this for a really long time, it becomes pretty obvious. And for some people, they would like a little bit more support in understanding that. So what this rule does is it defines the situations that require a move to the hospital. As someone else said, this doesn't necessarily mean there's something wrong. It doesn't necessarily mean the baby is in danger. But from our perspective in reviewing all of the national standards and all of the research, what it means when we see these situations such as bradycardia or tachycardia or decelerations is that it's time to move to the hospital and be in a place where we can get a little more information than what we can get at home. And it is certainly true that there will be clients who will end up in the hospital when maybe they didn't need to. But we also hope that it will improve safety and catch situations where people should be in the hospital. We also believe that, over the years we've made many revisions to these rules since before coming to TDLR. We've done regular rules revisions. And we consider them a living document that changes based on new evidence because, research changes all the time and protocols change, and our own experiences and complaints that we see. We really appreciate the efforts of the TDLR staff to work side by side with us. It's a complex issue. They've had to learn a lot about birth and, labor and delivery and things that, were out of their purview before, and we really appreciate how much they have learned to support our growth and how they work with us and listen to us. I just wanted to comment to add to what I was going to say, which is, Jennifer Kelleher, I think, made an excellent point about our expert witness process. I actually recently contacted staff, and we said we were going to have a conversation about that and get a meeting together to keep working on it. And I really appreciate, again, that they continually work on these issues to improve the process. So thank you for your time.
Thank you. I appreciate it.
Thank you. I can tell you generally, any other comments, Commissioner? As chair, I can appreciate your times and efforts to do this. This doesn't get any more granular than this, and your passion for your industries is to be commended. So thank you for taking that time, and thank you for speaking to us directly. It doesn't go unnoticed or unheard, and we will make sure and take all your comments under advisement. But thank you so much. Anything else, Tim? Okay. I started this before. I want to make sure I don't. All right. So we're going to adjourn to executive session. Consult with our attorneys under section 551.071 and 551.0712 Government Code. The time is 9:23.
I would like to say thank you to
Tamla? Same work for you. Okay, we're going to come out of executive session. Its time is 10:16, and we've concluded executive session. There's no action items to be discussed in executive session. I did want to go back to recognizing our new commissioner, Mr. Joel Garza Jr., with fresh out of high school. Is that what you do? Fresh out of high school. Are they younger, or am I getting older? What's the story? We're going to page you. You know that. Okay, just give you a few seconds.
Sure. I just want to thank the commissioners here for the opportunity to serve beside them, to serve our great state, to serve the great citizens of Texas. I want to thank the staff of TDLR for all their hard work. There's a lot that goes behind the scenes of what they do, especially now during legislative session. So I look forward to serving the citizens in the state and look forward to getting to know everyone here in the department. Thank you.
And we will keep attorneys separate at all times, because nothing good happens when two attorneys get together.
The economy grows.
I don't know about that. I don't know about that. All right, fellow commissioners, you got to look at your minutes of the meeting. I would entertain a motion.
I move that we accept the minutes as written.
Second. All in favor?
Aye.
Aye.
Opposed? All right, minutes pass out. All right, we're going to contested cases. I'm going to read this to you. If you make sure you guys pay attention to this, especially your first time here. If you're here to take your case and wish to speak to the commission, we'll call you up when we announce your case. We'll hear from the prosecutor first, and then we'll hear from, have an opportunity to speak. Make sure you fill out a public comment form, which should look like this right here. And if you want to speak and turn it into Ms. Fletcher, make sure you speak into the mic and say your name and who you represent. Now remember, the commission can only hear information that was in the record from when the case was heard at the SOA. So you must limit your comments to those matters that were presented in the SOA hearing. So anything outside that hearing, we can't discuss. I can't say that enough. We slip into that a couple times. So first case is Mr. Asaf and Alpha Record Service.
Good morning, Commissioners. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. The administrative law judge in this case recommends a $1,600 penalty and a full refund to the complainant. I ask that you adopt the proposal for decision as written. Respondent performed a non-consent tow of a vehicle from a parking lot of an apartment complex in Houston. During the tow, the owner of the vehicle confronted the tow operator from his second-floor balcony and specifically requested that the tow operator stop towing his vehicle. The ALJ found that the respondent's tow operator failed to inform the vehicle owner that he could pay a drop fee to avoid having his vehicle towed in violation of the department's rules. This is a Class D violation of the department's enforcement plan. Second, because respondent towed the vehicle in violation of department rules, the ALJ found that the tow was not authorized by the towing statute. This is a Class F violation of the department's enforcement plan. The department has the statutory authority to order a refund when a tow company charges more than the fees established by rule, and the department sought a refund in this case. The ALJ found the respondent charged a fee for a tow that was not authorized by rule. Because the respondent charged the vehicle owner for services that the ALJ found were not authorized, the ALJ recommends respondent pay a full refund of $222.51 to the vehicle owner. In summary, the ALJ recommends a $1,600 penalty and a full refund to the vehicle owner for 2 violations of the towing statutes and rules. I ask that you adopt the PFD as written, and I'm available to answer any of your questions. Thank you.
Any questions for Jessica? Okay, Mr. Bruce,
Thank you.
state your name.
Jonathan Bruce for respondents. It's our position that the rule as far as having to inform a tow truck or a vehicle operator that they can pay a drop fee should not apply in this case. First off, at the time, this was one late at night, at the time the vehicle owner appeared on his balcony at, I think, 12 or 1 in the morning or something like that, yelling down at the tow truck operators. The vehicle was not even hooked up. So no fee, there was no fee at that point. Secondly, but he didn't come down from his apartment. By the time the vehicle owner came down from his apartment, they were already gone. I don't think I understand the spirit of the rule is that if you walk up when somebody's towing your car, you should be able to pay a drop fee to get your car back, and so you don't have to go to the VSF to retrieve it. I don't think the spirit of the rule, I don't ever think the intent was a rule that you're being yelled at from a balcony and you haven't even hooked up at night, that we should have to wait for you to come down, and especially in Houston where we've had several tow truck operators assaulted by people. But just saying that they were in the vicinity, well, we have to look at this, some practicalities. That if he had come down and said, hey, don't tow my car off, I'm willing to pay the drop, or what can I do? Yeah, my clients had a duty, or their driver had a duty, to tell them you can pay a drop fee. But here, he's in a balcony and the vehicle is not even hooked up yet. So we just don't believe that that was the intent of the rule. Again, he comes down, they're hooking up, about to drive off. Yeah, they should have told him you can pay a drop fee. But really, I don't even think at the time the alleged violation occurred, there was not a tow. The vehicle had not been hooked up. And that's our position.
Yeah. Jessica, can you clarify what was said, from the second floor balcony, what was spoken?
Yes, the complainant basically stated to the tow operator, don't tow my car. The complainant testified that he had just returned home from work and was in the process of changing his clothes, so he heard the tow truck, went out, spoke to them, and then as he's going inside to redress and go down, during that time, they continued to hook up the vehicle and tow it away before he ever had the chance to come down and say, and then get them to presumably say, you could pay this drop fee. So, to say that, he was on the balcony, so he shouldn't have been offered a drop fee, it's kind of, I would not agree with that position because they didn't really give him the chance to come down.
I think he did have the chance to come down. At the time, his vehicle wasn't even hooked up. I don't know, there was we didn't get a clear answer. I don't remember how long it took him to come downstairs. But first off, how do my clients are supposed to know this is even the vehicle owner? You just have somebody yelling at them from a balcony.
I got a question. Oh, go ahead.
Where was the tow truck? I guess where was it placed in connection to the car?
It was behind the vehicle, blocking it. So backed up to it, ready to hook up. The car's parked and the tow truck comes up behind it.
I don't know, we have actually testimony whether it was backed up or just parked behind the vehicle. I don't think it was clear in the record.
I've seen tow operators. What do you consider the average time that he came out on the balcony, his truck was there, and the guy said, hey, don't tow it, I'm coming down. You know, what's the timeline for a tow operator to hook up a car and get it out of there?
3 to 5 minutes. Because they tend to take, because everybody uses tow books now, which is the program, so they have to take pictures of why the vehicle was being towed, and then they got to strap it down and put the lights on it. So they're
If he was trying to get dressed, because it said
Yeah.
he didn't have street clothes on.
Right.
So if he was trying to get dressed, I figured, if they're there and they went ahead and kept doing it, they could be gone in 3 minutes or so before he even had an opportunity to get dressed and get down there.
And appreciate this is not the middle of the afternoon at a shopping center. This is late night at an apartment complex where the gentleman is in his apartment. Again, not this client, but I had another client who, similar situations, I know this is outside the record, who the gentleman came out with a baseball bat and attacked their truck. Yeah, I'm sorry, I'm just using that by way of example. But there, I think you can't look at all these situations just through blinders. You have to take a totality of the circumstances.
But I understand that, but
Yeah.
that is the nature of the business as a tow truck operator, that you're running that risk that someone's going to run out.
Of course.
Right, so I would imagine that's why they're pretty efficient in towing in under 5 minutes.
Yes, they are, yes. And in a modern tow, the way a modern tow truck
Correct.
works too.
And I would imagine if somebody is willing to come out on his balcony undressed,
Mhm.
that it was probably pretty clear which car they were planning to tow.
Yes, but it's
No,
not,
just-
okay.
Okay.
Okay, go ahead.
So then would it be fair to say that they are in the mode of towing that car?
There was no testimony as to that, where they had not, at the time he was yelling at them from the top, saying they were not hooked up to the
I
vehicle.
understand they were not hooked
Yeah.
up, but I'm guessing, was it possible that they were gonna hook up to another car? That this crazy naked guy was just random, like the guys didn't think to say, which car is yours? We haven't even picked the car yet?
I don't think there was any testimony, that's out, I would be speculating
Well, your
on that.
guys weren't shocked, like they didn't question which car this guy was yelling about?
That, I'm gonna get outside the record, that is not uncommon for people to say, don't tow these cars off in apartment complexes.
He said, don't tow these
Or,
cars?
no,
little
you
cars?
asked me whether, to speculate what my guys thought. And my response is, and I have done over 1,000 tow hearings where these things come up all the
And
time.
let's, if you can answer the commissioner's question with reference to information
Okay.
that's actually in the record.
Other than him just saying, that's my car, there was no other way for them to confirm that was his car.
Okay. Any other questions?
How much is the drop fee compared to what he actually paid? Is it a standard drop fee?
It is a standard, it's in the rule, it's a lesser portion of the towing fee. I don't-
I believe it's half.
Half, okay, so half.
And actually, in the city of Houston, it doesn't apply until the vehicle's hooked up.
Any other questions? All right. They're going to be right back here, so y'all guys don't have to go anywhere. Commissioner?
I mean, I can make a motion at this juncture unless there's some other questions.
Any discussion? Motion?
Yep, so I move that we accept the PFD as written for the 1,600 and for the violations that are noted. And I'm not clear, has the refund been made or?
Not to my knowledge.
Okay. And I'd like to attach the refund with it.
Is there a second?
I'll second.
Second. All those in favor, say aye.
Aye.
Opposed? Motion carries. All right, Mr. John Porter, Elite Towing Service. Jessica, go ahead.
Thank you, Commissioners. My name is Jessica Hurtado. I am a prosecutor in the Enforcement Division. The administrative law judge in this case recommends a $2,500 penalty and a 1-year probated suspension of respondent's tow company license. I ask that you adopt the PFD as written. Respondent performed a non-consent tow from a condominium's parking lot in Houston. The ALJ found that the vehicle was parked with the consent of the parking facility owner in the resident's assigned parking space. Because the vehicle was authorized to park in the resident's space, the ALJ found the vehicle was unattended. The towing statute authorizes an unattended vehicle to be towed only under the specific circumstances listed in Occupations Code 2308.251A. Respondent testified that he towed the vehicle because it was inoperable, not street legal, and was a nuisance. The ALJ specifically found that a damaged car seen as a nuisance is not a reason to conduct a tow listed in Occupation Code 2308.251A. Further, the ALJ specifically found that the vehicle, while damaged, was still operable at the time it was towed. Thus, the ALJ concluded that respondent did not have a valid authorized reason to tow the vehicle. Towing a vehicle without legal authorization is a Class F violation of the department's enforcement plan. As a result of respondent's actions, the vehicle owner lost possession of the vehicle because she was unable to afford to retrieve it from storage. In accordance with the department's enforcement plan, the ALJ recommends a $2,500 penalty and a 1-year probated suspension of respondent's tow company license. I ask that you adopt the PFD as written, and I am available to answer any questions.
Any questions for Jessica?
Was this, Jessica, the same one that, where the apartment complex or the condominium said we did not authorize the tow?
Right.
Okay.
Okay. Any other question? Mr. Bruce?
Yes, a couple of things. First off, the statute does not say that. It doesn't say these are the only reasons you can tow off an unattended vehicle. The statute says this is where you can't park. It addresses the vehicle owner, not the tow truck company. This is an ongoing issue we're having with the commission, from Black Bull towing to on-site towing to this case. And what the effect of this case is going to be basically to put the private property towing industry, probably take away 60 to 80% of their business. Because if we're going to read the statute that you can only tow off for these limited reasons, on-site towing and Black Bull towing dealt with apartment complexes. Now we're expanding that to every parking facility. Basically, this will put most private this decision will put most private parking tow companies out of business. This was towed off because the homeowners association had rules that your vehicles had to be operative. The front end of this vehicle, the bumper had been ripped off, and it was leaking fluid, and I believe it had a flat tire. My client towed it off per the homeowners association rules. And what basically this decision says is, we as homeowners associations can't make our own rules. Our condominium associations can't make our own rules. You're stepping on property owners' rights. I'm sorry, go ahead.
No, that's right. Go ahead.
And so that was the situation. The car had been stickered. The vehicle owner had been put on notice of it. They moved it from one spot to another. Although the front bumper was missing, I think some of the headlights were broken. And my client towed it off. And per the homeowners association rules that this homeowner had agreed to, a resident. This is not at an apartment complex. This is at a condominium complex.
You're saying.
Yes.
Did anyone contact or request the services of the towing company to tow the vehicle away?
Like in 90% of private property tows, they're done on a patrol basis. The tow truck company is hired to patrol the apartment or the condominium or the parking facility, and says in their contract, it says, here's what you can tow off for. So was there a direct conversation saying, tow this particular vehicle from homeowners association? No. But my client had a contract authorizing him to tow off cars in violation of the homeowners association rules.
You mentioned a sticker that was put on the car?
Right.
What did the sticker say?
Just basically the car had to be moved because it was inoperable or was subject to being towed.
And who put that on there?
My client, prior to the vehicle being towed.
Because it says in here that he testified that he contacted the management company before he towed the Mercedes,
Yes.
and they never heard back from the owner. So
Right,
does he feel
exactly.
like at that point, even if he doesn't hear back from him, he still has that right?
Yes. I mean, there was no doubt that this vehicle was in violation of the homeowners association rules. Why do people have the homeowners association rules have? Because they don't want broken down vehicles on their property. I mean, nobody wants to see wrecked vehicles in a condominium complex. I mean, and to say that my client should get a 1-year suspension or a probated suspension for following the homeowners association rules, this, that's what he was hired to do. And again, this gets back to this reading that TDR has taken and the commission has kind of backed up in Black Bull and Onsite, saying that those two sections, saying this is where you can't park as a vehicle owner, are the only reasons a vehicle can be towed. Because under that reading, those are very limited circumstances. As I argued in Black Bull and I argued in this case, that means you could park a car across 3 parking spots and there was nothing that the property owner could do about it.
Do we have a copy of what was actually put on the car?
I don't think there was a picture of it.
When was the sticker put on?
I believe it was a few days before, or a week before. It's been a while.
All right, Brad, you guys?
No, I was just gonna, this is Brad Bowman, I was just gonna ask if that was in evidence. the
I
sticker.
think
There
it was
are
testified.
photos in evidence of the sticker. I don't know that it's legible.
The sticker's not legible, or because
You-
of the photo, or it's just not a legible sticker?
The photo is taken from a
Distance.
distance, right?
Okay.
Can I see the photo? Yeah.
And just in one comment, Jessica also commented that the vehicle owner lost her vehicle because she didn't go and get it. The chapter provides for $25, or that she could have filed for a tow hearing to contest the tow.
Is
But
the
she-
sticker the orange thing, or which?
Yes, and I would say
The orange or the white?
the orange, but I would say that sticker was placed on there. The car was subsequently moved and then towed after that, so.
So nobody from the homeowners association has, I've been a part of a couple of them.
Right.
And they usually, the HOA usually has somebody who, it's not usually hard to find. They get somebody that'll go around and make these nuisance calls or inoperable car.
Right.
And do that, but you're saying, from what I'm seeing in the record here, that wasn't done, this was all done by the operator. And he didn't get a call back from the management company, and so he just took it upon himself to say it was inoperable.
Well, one of the issues was that this resident is not, this is a registered owner. This is not the property owner.
It was a guest.
I believe I think they're tenants. So there's not a way to contact them directly. But again, in the circumstance, it clearly violated the homeowners association rules. My client has authorization to enforce those rules. And to say that we're going to get a year probated suspension for doing the job that we were hired to do. And as you saw in the pictures, the state of the vehicle.
And is the home association, so I can understand the language, is that the same as the Doma Chase Management, or?
The management company is hired by the association to.
Got it.
And if I could just say, Mr. Bruce's position is the car was not operable, but that's not what the ALJ found.
Right.
There is the ALJ weighed the testimony of both parties and found that the vehicle, while damaged, was operable. It is not up to the tow operator to decide that a car that looks ugly is not operable for whatever reason or whatever criteria he determines. And to decide that he's going to tow a vehicle, basically because people complained that they did not like the way it looked. I mean,
If I may respond to that, it is up to the tow truck operator at the scene to make a determination. Everybody, that's what they're hired to do. There are going to be close calls. They're going to look at a vehicle and determine whether that vehicle is operable or not. They may be wrong, and that's fine. But but that's not a violation. They may ultimately be proven wrong. The person could have filed for a tow hearing to have this resolved. But they're the person at the scene making that decision. That's what they're hired to do. In a sense, that's their profession, is to make a determination whether a vehicle can be towed or not. Are they going to be right 100% of the time? No. Is that a violation just because they it ultimately proves the vehicle was operable? You saw the pictures, it looks inoperable. I think you can make, a reasonable person can look at those pictures and say that car looks inoperable,
Well, actually, I tend to disagree with you on that.
Okay.
Because both tires in the front look operable. Like you said, the tire was flat. It
but-
looks like it was drivable and movable. Does it look pretty? No.
It has to be street operable. It's not just, operating,
But I
working off.
can't tell from that picture whether the lights are operable or not. And for all I know, she could have been still haggling with her insurance company over who's repairing the vehicle.
And I will grant you that, but making a judgment call at the scene does not constitute a violation. He made a judgment call to say this vehicle appears to be inoperable, and it has not been moved. As he said in the testimony that he had put a penny on the tire and the vehicle hadn't been moved for some time. So he made a call that it was inoperable.
But I thought someone said the vehicle had been moved to a different spot.
It had been moved.
To
It
a
was
different
moved.
spot, but then they re-tagged it, or they said it never got moved from the new spot it was there for some
The
time.
resident's assigned spot where
Yeah.
the car belonged.
But the resident agreed to make sure their vehicle was in an operable condition. And my client made that call, the judgment, it didn't appear to be operable, that they couldn't have turned the wheels due to the bumper.
Okay. Any other questions?
And again, I just don't think, let's just assume on the fine, but a year probated suspension for making a judgment call?
Okay. That's fair. Blessing, Commissioner, you got anything?
Well, it said in here that this was a second violation for, was the first one the same as this, or?
Yes, just 1 second.
And to clarify again, forgive me, so the Doma Chase Management, working on behalf of the Home Association, did not call to move the car or to tow the car?
But they don't have, under the standard contract gives that, they just get a broad, tow truck companies are given broad authority.
My question was
Okay,
directed
I'm
to the
sorry.
prosecutor.
Oh, this was in 2016.
2016 for towing a vehicle without proper signage present.
I'd like to make a stab at this.
Sure.
Okay. And I'm going to move to change the,
Modify the PFD.
yeah, modify the PFD. And Brad, I may need your assistance on this if there's anything we need to change on the findings of fact and conclusions of law. And I'm going to explain to why I'm coming to this conclusion is I think if a tow operator is going to make a judgment call, he better make sure that car is not operable. And I'm not sure that car was not operable. But I don't think that decision should stop him from working. But I think he does run the risk of a penalty on it if he's going to take it under his own decision to make a judgment, whether it's operable or not, without getting a confirmation from the condo association to order that.
I understand.
Okay, so I'm going to move that the fine remain, but that the suspension be removed from the license.
That would just be a change to conclusion of law number 8, I believe.
Thank you. Okay.
Right.
Is there a motion?
Yes, that's my motion.
Okay.
I second.
Second. Any discussion?
I was gonna say that I agree. This is a judgment call. It is their livelihood, their job, and sometimes you run into these situations under the authority of the homeowners association. But like the commissioner said, that we need to be mindful and look at it holistically in a manner that we can let them continue working, but be more careful about those judgment calls next time. So just to add on that makes sense.
All right, we'll vote on the motion. All in favor, say aye.
Aye.
Opposed? Carries. Thank you.
Thank you.
All right, Mr. Martinez, Fusion Collision Center. Or collision. Depending on the case. I'm a projection. Mr. Martinez here? Okay. Are you, Jessica, you're on this one too?
Yes, Commissioners, my name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. The ALJ recommends a penalty of $4,800 for 3 violations of the vehicle storage facility law and rules, and I ask that you adopt the PFD as written. The respondent is licensed as a vehicle storage facility. Respondent accepted for storage a 2016 Ford F-150 with a Colorado license plate. Respondent published a first notification that did not include all required information. Second, respondent failed to publish a second notification as required by law, and despite failing to provide this proper notification to the vehicle owner, respondent then took possession of the vehicle by transferring the title into the respondent's name. Respondent's actions resulted in the complainant's loss of the vehicle. Based on the department's enforcement plan, the ALJ recommends a penalty of $4,800 for these 3 violations. I ask that you adopt the PFD as written, and I'm here to answer any questions.
Any questions for Jessica?
Yeah, is this a first offense?
It was pled as a first offense, yes.
Okay, and what is the range of punishment?
Just one second. So for the first violation is a Class B, $600. The second violation is a Class D, $1,200. And the third violation is a Class G, $3,000.
And so how can we jump to 4,800?
4,200 and 600 is 4,800.
No, that's what I'm trying to figure out.
Yeah.
How are we getting to the?
It's the 3 of them combined.
Oh, okay. But they're all first offenses, right?
Yes.
And it's all basically on one action, though?
It is one action.
Okay. I'm just trying to figure out what you charge if it's a second offense.
A lot.
Yeah.
Any other comments?
No.
Okay, I'll entertain a motion.
Is the other side here?
No, we asked Mr. Martinez.
Oh, I don't care.
Motion?
Yep. I move that we adopt the PFD as is.
Second? All right. All in favor, say aye.
Aye.
Opposed? Motion carries. All right.
Thank you.
Mr. Nguyen. Ken?
I mimeographed some handouts for you.
Use bold letters, small words. Good.
I'm not smelling anything on it, are you sure? With the purple.
Oh, my childhood.
I like this.
You're dating yourself.
I like this a lot. He's doing this.
I had it on good authority that this might be helpful.
This is always helpful. This is always helpful. Just to let you know that, fellow commissioners, I asked the enforcement agent to put things more in sequential timeline because we always have the dates. And being an Aggie, reading's not my strength, right? So I've asked them to do, and I would appreciate that. So if you guys like this, please let enforcement know. Go ahead, Mr. Stark.
Thank you, Mr. Chairman. The respondent in this case is Hoa Van Nguyen, and we have a translator here, An Ninh Nguyen. And since they're not here, and I understand they're not here.
Mr. Nguyen, I've asked, I don't know.
Okay.
I don't have a form for him.
Okay. If possible, then, with your permission, we release Ms. Nguyen.
Absolutely.
To return. She's a staff in the driver's license division. We sure appreciate her coming out this morning. especially
Customer
on-
Service Division.
Thank you.
Or-
Customer Service. There's too many bills to transfer driver's license from different programs. I don't want that rule to start today. It's coming.
Okay. She is one of our family here at TDLR.
Thank you so much. Thank you. You can go.
Yeah.
Don't worry, Ms. Yarko will translate Vietnamese if we need her to. Don't worry about it.
Yeah. Thank you.
All right. Thank you, ma'am.
Thank you. Well, the department issued a cosmetology, well, I should announce my name for the record. I'm Ken Sharp. I'm an enforcement prosecutor with the Enforcement Division here at TDLR. The department issued a cosmetologist manicurist license to Mr. Nguyen in 2001. Because of his criminal history, the administrative law judge recommends that you revoke that license. Mr. Nguyen applied to renew his license in November 2017. And he answered no to that question on the renewal application that asks whether, since his last license had been issued, he had been convicted or placed on deferred adjudication for any type of criminal offense. But that answer was false. In January of 2017, Mr. Wynn was placed on deferred adjudication community supervision after he pled guilty to a lesser included offense of injury to a child by recklessness, which is a felony. He had originally been charged with sexual assault of a child, indecency with a child by contact, and indecency with a child by exposure. Those charges and the charge he ultimately pled guilty to pursuant to a plea bargain arose after the authorities learned that he'd been sexually molesting his own daughter over a 7-year period that began when the victim was in the 5th grade at age 12, approximately age 12. The ALJ concluded the deferred adjudication should be treated as a conviction for purposes of licensing, and she also noted that Mr. Wynn would have further opportunities to engage in similar criminal behavior as a manicurist, because in that occupation that would give him direct contact with members of the general public, and that would include children. This is consistent with the Department's criminal conviction guidelines also. They recognize that contact could occur with children without anyone else being present. The ALJ considered the evidence and found that Mr. Wynn was not truthful when he answered no to the criminal history question on his renewal application. And the ALJ concluded that Mr. Wynn currently lacks the fitness, the honesty, the trustworthiness, and the integrity to hold a cosmetologist license, and recommends that you revoke that license. The department asks that you adopt the PFD as it's written. Thank you.
Any questions, Mr. Sharp? I'll entertain a motion. A second? All in favor?
Aye.
All right. Don? I think that, okay. And Mr. Bruce, you're back.
I'm back again. Last one, I promise, for the day.
All right. You got a 3-for-1 deal?
I got, yeah. Gonna get up at 4:30 in Houston and drive up to Austin. You know, gotta make it worth my while.
I know where you get to stop on the way.
That's right.
Ken, you're gonna substitute for Trevor?
That'll be on the following cases.
As well?
This is Mr. Shirk here, but Ken will come back up.
Okay.
Yes, sir.
Mr. Chairman, Commissioners, good morning. Michael Shirk for the Enforcement Division. This is a case that stems from a proposal for decision that was issued by the Administrative Law Judge on November 7, 2018. The Administrative Law Judge found that respondent had performed 3 illegal tows. For each one of those tows, it's a Class F violation, which is a $2,000 penalty. So the Administrative Law Judge recommends a $6,000 penalty, and we, of course, agree and hope that you will adopt that. Significantly and somewhat surprisingly, however, the Administrative Law Judge found that the Department was not authorized and does not have jurisdiction to order refunds in cases of this nature. This was very surprising. In fact, you just did it in a case before. So we're asking that you adopt so much of the proposal for decision, which enters a $6,000 penalty against respondent for the 3 illegal tows, as well as amend the proposal for decision to order refunds in the amount of $230.51 for the Toyota Camry, which was towed from the Cambridge Place Apartments, and $221.51 for the tow of the F-150. I'm available to answer any further questions if you have any.
Sorry, Michael, thank you.
Of course.
Any questions? All right, Bruce, state your name, please.
Jonathan Bruce for the respondents. This case involved 3 different tows. One tow, the first one was from a restaurant after hours, a sushi restaurant. Our spotter testified that he believed he saw the vehicle owners go across the street, and then he called the restaurant, and he was told there was nobody else in the restaurant. It was all clear. The second tow was from a country western bar, where there was no doubt that the person whose vehicle was towed was not properly parked, had gone to a different bar, and my client was working under a subcontractor agreement with the main towing company. And the last one was from an apartment complex, where there was some question where permits were required in the apartment complex and not. And all 3 of these, and this comes back to my others, these were not intentionally towed in violation of the statutes or anything like that. My client thought that they had authority in each one of these cases to tow these vehicles. Understand the ALJ judge didn't believe, based on the evidence, that the cars were unauthorized, and didn't feel that they could have a subcontract agreement with another tow truck company. We just asked for maybe this is the first violation, I believe, and maybe a little modification on the fine, on the amount of the fines. I don't disagree with Mr. Shirk as far as the ALJ being the TLR having authority to order refunds or request refunds. I don't disagree on that. But I would ask, just based on the nature of these, there was no intent. It was, again, a bad judgment call, possibly. I think we have some conflicting testimony, certainly on the restaurant tow, but we just asked for a bit of a fine reduction on these.
Any questions for Mr. Bruce? Mr. Bruce, I think, any other comments?
No comments on my end. So, well, yeah, no comments, because I'm assuming, well, I don't want to make an assumption, you said they had a subcontract agreement with?
With the towing company. Sarah Investments had the actual contract for the Wild West Club. My client had a subcontract agreement through Sarah Investments. But it was not, as the LJ is correct, there is not a contract with Wild West per se.
Directly.
Correct,
Okay, got it.
yeah.
Okay, all righty.
Although I think there was testimony that Wild West was aware that my client was doing some of the subcontracting. Okay.
So I'll adopt a PEFD as issued, but with the, instead of the fine being $2,000 each, if we can do it $1,000, and with the reimbursement.
May I address that?
Go ahead.
I think that the penalty plan that was adopted by the commission sets a first penalty for a Class F at $2,000. Administrative law has two purposes. The first is specific deterrence, to keep the person who wronged in the first place from doing it again, but also general deterrence, which is to send a message that the tow of a citizen's vehicle is a great inconvenience and indeed puts them at risk, so that the deterrent value of the penalty is significant. This is not a punishment for the tow truck operator. I believe that the commission came into the decision to use a $2,000 penalty for a first offense after giving it consideration, using the factors that are laid out in the enforcement plan, and that it is an appropriate first penalty for purposes of general deterrence to make sure that other companies are careful when they choose to tow cars, and also specific deterrence that this company may be a little more careful in the future. So I would ask that you retain the $2,000.
Mr. Chairman, Brian Francis, while I agree with Mr. Shirk's understanding of the reasoning for it, but that penalty amount holds the staff and the department to the guideline. The commission has the ability to set those penalties at whichever level they want. That does not hold the commission tight, so just want to make sure that you recognize that penalty amount is not binding on you.
We have latitude.
Absolutely.
Okay. Did you want to?
And just
Well, obviously, I had a motion on the.
Yeah, you
floor.
did.
So-
Was there a second? Is there a second? I didn't know if you wanted to modify it after hearing the enforcement.
There is a second, and I do appreciate what
Okay.
Mr. Shirk's
Discussion.
coming from, but I also appreciate the legal fees your clients are paying. And so, as long as the state of Texas consumers are being reimbursed and we at least have a solid $1,000 penalty, I feel comfortable seconding that motion.
Okay, so we got a motion to reduce it from 6 to 3. Is that accurate?
Yes.
Okay. You got a second? Any other more discussion? Okay. All those in favor of the motion, say aye.
Aye.
Aye. Opposed? All right, motion carries.
Thank you.
Thank you. Schindler Elevator Corporation.
Thank you, Mike.
Robin.
Commissioner, the next case on the docket that I have is Fong and
Oh, I'm sorry,
Condon.
I'm sorry, I
mean,
apologize,
we
you're
can-
right, I skipped one.
Okay.
I
We can come back.
It's Mr. Codon, sorry, apologize.
Condon or?
Condon, Fong, Condon, and Robert. There you go. All
Morning,
right. I want to give everybody in the room permission to be wrong, since I've been wrong so many times, so we have freedom now, so.
Great job.
Quit whining. All right, go ahead, Ryan.
Good morning, Mr. Chairman, Commissioners. My name is Robert Reyes, and I represented the department in this action before the State Office of Administrative Hearings. In the proposal for decision issued August 24th, 2019, the ALJ found that respondent performed pedicure services without being properly licensed. The ALJ recommended a penalty of $200. However, the ALJ erred by incorrectly applying the penalty matrix found in the cosmetologist enforcement plan. While I am not requesting a modification of the penalty amount in this case, I do recommend that you modify the conclusions of law stated in the PFD to accurately reflect the Commission's adopted enforcement plan for cosmetologists. The current version of the enforcement plan for cosmetologists was adopted by this Commission in 2013. Respondent was found by the ALJ to have performed an act of cosmetology without first obtaining a license on March 16, 2018. Respondent's violation, her first, is a Class F violation in the enforcement plan. The Commission adopted a set penalty amount for this exact situation, $1,000. In conclusion of law statement number 9 of the PFD, the ALJ inaccurately states that the Department's cosmetologist penalties and sanction plan provides for a penalty of up to $1,000. This is an incorrect application of the penalty amount. The penalty amount is not a starting point for a range. The Commission did not adopt a range for a respondent's first violation of a law categorized as a Class F. The Commission did, however, adopt the single penalty amount of $1,000 for a first-time Class F violation. The penalty amount applied should be a deterrent against future unlicensed activity. Unlicensed practice is a direct threat to the safety and welfare of the public, as utilizing incorrect hygiene and sanitation procedures could compromise the health of our citizens. I request that conclusions of law 9, 10, and 11 be modified to accurately track the actions this Commission took when adopting the single penalty amount of $1,000 for the violation of a law classified as a Class F violation. I'm here and available to answer any questions you may have.
Any questions?
All right. So the violation was simply because she didn't have a state of Texas TDLR license?
Correct.
Was there wasn't anything else that she was doing, unsafe practices, unsanitary, anything of that nature?
The inspection report came back for an unlicensed activity. That was all that was gleaned from that inspection report, and that's what the NOAV was based on.
Or remind Commissioner, we have the latitude to change the fee, but his point is, the statute says, is that accurate? Right.
This
We
is
have the
Brad
latitude to
Bowman, General
modify
Counsel.
it.
Yeah, the commission is not bound by the penalty matrix or what the judge recommended as a specific penalty. You have up to $5,000 for under the statute or anything below that.
But
I think what the prosecutor was referring to was the judge's description of the penalty matrix, that it's a single amount that's noted in the penalty matrix rather than an up to. But again, the commission is not bound by
Just want to make sure that that's your point.
Yes, sir, exactly.
Okay. Any other comments?
That modification that you wanted to put in there in the PFD, as is written, you were saying something about.
Yes, sir.
Go back to the 2013.
Oh, I'm sorry, Mr. Commissioner. The current version of the enforcement plan that includes the first-time penalty amount for a Class F violation is $1,000. It was just to exhibit to the commission that this rule and this amount was already well in place before the violation occurred.
I misunderstood that.
Okay. I can respect your position on behalf of TDLR that, wanting to enforce our rules, but with her husband serving in our military and her recently relocating and just not realizing that she had just moved here and then immediately trying to comply, I must admit, I'm going to move to adopt the PFD as written with the nominal penalty of $200.
And just to be clear, Commissioner, I'm not asking for $1,000. I would like to keep it at $200.
Okay.
What I am requesting of the commission is to not adopt dicta that is incorrectly applied to the situation. I would like the commission to state that a Class F penalty is only $1,000. However, I would like to keep the $200 if you
Right.
would like to.
So she's just modifying that the ALJ
Sure.
stated it was up to, and that's inaccurate in his opinion.
Okay.
Chairman
So-
Figueroa, if I can jump in, and
Sure.
Robert's done a great job of talking about this, and he talked to me about it as well. We're just trying to uphold that the department staff and the ALJ, we don't have discretion. Discretion lies with you.
Makes sense. I got you now.
Okay, absolutely.
I got you.
So
Okay.
you just want to make sure that's stated for, Brad, do we need, on that motion that Commissioner Yurkos, does she need to state
Withdraw it?
that? Or
You could-
restate it?
Or you could modify your motion to modify conclusion of law number 9. That has
Sure.
the
Let me
prosecutor
move
recommend.
to, yeah, let me modify my motion to modify conclusion of law number 9 as recommended by you.
And I do have specific language if the commission would be entertained to listen.
Is that necessary, Brad?
Do you want him to read it into the record?
If that's, yeah, that's fine. I think it's getting rid of the up to language. Is
Right,
that
that's it.
correct?
Just getting
That's
rid of it.
exactly correct.
Okay.
Perfect.
Strike it. Right, striking the up to.
Yeah,
And
no,
then-
no, it's.
And you're keeping the fine at 200.
Correct.
Correct. Okay, so
And
that's the
then-
motion?
And then we need a second to
Second.
I got a
concur with
second. Any other discussion? All right, all in favor, say aye.
Aye.
Opposed?
Okay, and before you leave, can you explain to me the pattern on your socks?
The socks. The socks are from the Deep Eddy Distillery out, going out west, and it is a, supposed to be a silhouette of one of the mascots or one of the ladies dipping her
Okay, we got it
toe
up there.
in
We
the,
got-
in the Deep Eddy pool.
No, I've been waiting. Go ahead, go ahead.
That's exactly what it is.
Carol, thank you very much.
Thank y'all.
Thank you so much for that.
Oh,
I've
sure
got,
thing.
I've got HR right here on point.
Yeah.
Don't worry.
Who wore he chose to wear these socks? I was so doing it on the record.
They were my only blue socks. I did not have any other socks.
Friday, it's all right, it's Friday.
Robert, we appreciate your sock.
Thank you all very much.
And, Mr. Francis, can we get Ms. Yurko her 88 minutes? Because she's
Absolutely, absolutely.
Very medicated. All right, now, Robin, where you at? Thank you. Thank you for the correction. Schindler Elevator Corp.
Just trying to keep the integrity of the.
I like your socks. No socks.
Yeah, no socks over here.
Keeping it simple.
It's like I'm so calling him on that.
All right, has everybody filled out a form? I haven't. Have you
Jim
filled out-
has.
I don't think I have a form for him.
Tim, is the chairman, the chairman?
I don't think we have a form for you, sir.
I was unaware that that was a requirement when you were
Okay,
representing
yeah.
somebody.
I'll tell you what, let's
Who's next?
hold you guys, you're gonna need to fill a form out before we get you on file, so we'll just skip to the next one, come back right to you if you don't mind, right?
That works.
Or you wanna fill that afterwards, is that easy?
That's fine.
That's fine, okay.
Absolutely,
We'll
that's
do-
fine.
we'll do that. My attorney said you can fill one out. Very expensive. Go ahead.
Good morning, Commissioners. My name is Robin Glassner, and I am a prosecutor in the Enforcement Division. I represented the department in this case. The administrative law judge in this case recommends a $3,000 penalty. I ask that you adopt the PFD as written. Respondent, a licensed elevator contractor, released an escalator back into service after an accident involving a 5-year-old boy occurred. Specifically, the boy's hand became stuck in an escalator handrail inlet at a Sears store in Dallas, Texas. EMS was called to the scene and removed the boy's injured hand from the handrail inlet by cutting the handrail inlet off. The boy was taken to the hospital for medical evaluation upon EMS finding that the boy's hand was bruised and bloody. The escalator was locked out of service immediately after the accident, and Sears filed an accident report with the department within 24 hours, as required by the department's rules. Sears contacted the respondent and told them not to place the escalator back into service without the department's approval. The respondent repaired the escalator and placed it back into service without first having the equipment inspected and obtaining approval from the department. The ALJ concluded that an accident, as that term is defined by the Texas Health and Safety Code, had occurred. Therefore, a respondent had a duty under the department's law and rules to not release the escalator back into service until an inspection had occurred and approval given by the department. This is a Class C violation under the department's enforcement plan. The ALJ recommends a $3,000 penalty for the Class C violation. I ask that you adopt the PFD as written, and I'm available if you have any questions.
Thank you, Robin. Any questions for Robin? Okay. And I didn't catch your names.
Lawrence Taylor, Schindler Elevator Corporation. Before we get started, do any of you guys even have an idea what a handrail inlet is?
I want to make sure everything you say has to be stay within what was presented at the SOA hearing, so we have.
Well,
to stay-
a handrail inlet is what they're alleging is supposedly happened, and I figured you guys have no idea what that is. So I brought a picture for you if you'd like to have it. If you don't, that's up to whatever you want to do.
This was not an exhibit entered at the hearing
well, then
when
we
they
can't-
have
we
the
can't.
opportunity to do that.
All right, well, and before I get started, I'd like to address to Brian down there is that I want to apologize in advance because I'm going to have to say some uncomplimentary things about people that work for you.
Sir,
and-
sir, make sure you direct.
Oh, I'm sorry.
comments to us, please.
I'm going to have to say a few things about this entire process that has gone on that is uncomplimentary to people in an agency that I dearly love and care about.
As long as it stays within the case that we have in front of us.
I'm going to actually take the judge's ruling and go through it item by item, point out inaccuracies that are, this doesn't state the facts. Some of it does, but a big chunk of it is just not true. And I thought truth trumped assumptions and innuendos. I hope it does.
Well, let's go through it.
Okay.
And I'm sorry, are you an attorney for Schindler, or what's your role with?
I am the Codes and Standards Officer. I did play an attorney in high school one time, but that's it. Okay. And it was Atticus Finch, too, by the way. All right, going through using solely the document, the finding report from the ALJ.
The department asked that the commissioners recognize none of these were brought up in exceptions that were allowed to be filed after the PFD was issued. That was really the time to tell the judge any inaccuracies that they thought had occurred, and no exceptions were filed by the respondent.
I'm confused too. You're not a lawyer.
No, sir.
But you're here representing who?
Schindler Elevator Corporation. I would like to point out, we couldn't know that there were inaccuracies in this document until we got them. We had never envisioned in a million years that an ALJ would have a casual acquaintance with the facts.
Okay, well, other than that, sir, Red, are we able to admit, talk about this even on this time?
Because of the exceptions
Yes.
issue, I think the prosecutor was pointing out that Schindler had the opportunity to file exceptions and did not to the PFD. So that's a process that happens at SOA, filing exceptions. If you disagree with the PFD, either party can file exceptions to those items they disagree with, and that did not happen here. I think that was it doesn't preclude the commission from considering the PFD or arguments from Schindler, but I think it was pointing out for the record that that did not happen.
Yeah, so basically, we can, if you have an issue regarding the PFT, that's.
And I actually had obtained the audible record of the testimony, and everything that I intend to point out that is a mistake, as far as I can tell, is based on testimony that took place at that hearing.
And were you there?
Oh, yes, ma'am, I was.
Okay. Go
Okay.
ahead.
Item number 1 is on page 2, the very first paragraph. We have all along contended from the very beginning that there was no accident reported. It was an incident reported. The form on which the daggone thing is reported is called an incident report, not an accident report. And it is a common practice and has been for since this first came into effect in the 2001 legislative session, that if an owner wants to file a report regardless of whether or not it's an accident, that's defined by law, not as defined by TDLR. They could do it and do it all the time. That report used to be titled an accident report.
Okay, none of this was on the record.
But that's not in the, okay,
None
we'll
of
forget
this
that.
was
Right.
said during the
I
hearing.
can't say again, stay within this contained, because we don't want to wander out that.
If I wander, please, if I get off the reservation, just,
I've got 3 people watching me.
I'm sure of that. Oh, by the way, welcome to the jungle with your new position and yours too. No, this isn't, okay, that's not in the thing.
And Jessica, do we have a copy of that, whatever was Is that in the record as it?
Yes, a copy of the incident report is in the record.
And that's all that we're going to talk about is what the ALJ ruling that he issued, which we believe is in direct conflict with the facts. To go along with what I first said, in the at Chief Elevator's own testimony, it was mentioned that not every report that they get is an accident.
Okay,
And a piece of paper doesn't make it an accident. It is what the law says an accident is defined as. Okay. The ALJ has, in our opinion, seriously erred in his determination that says a cut or a bruise, regardless of how minor it is, if there is the presence of blood, that is somehow a serious dysfunction of a bodily organ. That's just, it boggles my mind that an educated person would say that. People can cut themselves all the time, and that doesn't give them a serious bodily dysfunction. And that is a requirement of the law. It's not the requirement. It says in the law, the definition of accident is a major impairment to body function or a serious dysfunction of, and I'm paraphrasing, but serious dysfunction of a bodily organ, comma, that requires medical attention. If it's not a serious dysfunction, which I don't believe that there's any evidence to prove that, it's not by definition an accident, therefore we shouldn't be sitting here today.
Mr. Chairman, may I just ask one quick question, not to take us off track here, but we were noticing in the PFD that there was an attorney that represented Schindler at the hearing, and I'm just curious, I just want to make sure that that attorney no longer represents Schindler in this matter.
He had a conflict, couldn't be here.
Okay.
Otherwise, I wouldn't be here.
But the
Okay.
company is wanting to proceed
Without the attorney.
without the attorney.
Right, and so
Yes.
noted. We want to make sure, so that's the case.
Yes, sir. Yes, sir. The ALJ, again, ALJ, we believe, has complete.
You have that option. You could reschedule if you want a continuance for this, if you.
Well, I wish I had known that before my mother's brother died on Wednesday, and I missed a funeral in preparation for all this. But I'm here now. I just soon proceed, if it's okay with you guys. I don't know. I'm sure everybody in this case, including TDLR, is growing a little weary of it, and I certainly am. You can cut yourself, and that just the mere presence of blood does not a serious dysfunction make. The law is very clear. Now, this isn't in, I don't know if I can even say this or not, but I contacted a state senator's legal department who reviewed this law.
Okay, this is way far outside the record.
I would hasten you to focus on the violation of what we're doing.
Well, then let me
That's
do-
what
let
we're
me do
gonna
just
read.
that.
The $3,000 to get the escalator
Okay.
back in, was she stated it, so if you could focus on that, that would.
I
help
know,
expedite.
I'll do my best, catch me if I want to. The definition in the law, the ALJ, is just, he has gone off the reservation with determining that any blood, it's not a serious dysfunction. Could
Okay,
be.
Let's continue back to the
Okay.
violation. Go ahead.
Yeah,
Okay, just continue, go ahead. And I want you to focus in on that, that's
Well,
what we're trying, that's a germane issue here.
It is absolutely germane.
Okay, so.
Without a serious dysfunction, an accident did not occur, a serious bodily injury did not occur. Therefore, we had no obligation whatsoever to seek TDLR's permission to do anything. This entire incident, as the evidence clearly shows, what little evidence TDLR has, is this was a self-inflicted wound by the child who
Okay,
was.
that was not in evidence either.
I believe it is.
Yeah.
They document.
Can you prove that it was an evidence?
Yes, I think I can. If you give me a second. And there is the actual report itself that was part of the documents inserted. Was going down the escalator and his right hand stuck in the handrail over the end of the escalator.
Robbins, is.
It's right here.
The incident report's is in evidence, but an interpretation of that report is not.
Right.
Well, that's, I mean,
Again,
I'm trying to.
I got you, so again, it's good.
In order for this event to have happened, that escalator did not reach out and grab that kid. And sorry, as terrible as it was,
we're trying to focus again on.
But it doesn't, the entire thing doesn't
Sir,
meet that
sir, hang on,
definition.
hang on a second. I'm trying to guide you through this. I know it's kind of tough. You get your, and so I'm giving you as much latitude as I can.
And I appreciate that very
Okay,
much.
got it. Again, I don't want to argue the dramatics or the grammar on this stuff. I want you to tell us if there was something misapplied or if we did.
It was completely misapplied. I don't, it doesn't meet, if it doesn't meet the definition, it's misapplied.
That's your case?
Absolutely.
Okay, okay. Is there any questions?
Do we have a difference between an incident and a serious bodily harm?
Well, and I can clarify a few things. One is, and the ALJ found this in his PFD, if a owner, so if the facility owner files an accident or an incident report with the department, then the contractor is under obligation to not release the equipment back into service until it's both been inspected and then approved by the department, and that is purely for the health and safety of the public. Because if equipment, a lot of times if you have an accident, equipment's damaged. That's pure and simply the reason why the rule is written the way it's written, the laws are written the way it's written. That's what number one, what the judge found is that an incident report had been filed. Schindler knew about it. Therefore, under their just basic duty to the public, they were required to follow department laws and rules by not releasing the equipment back into service without having the inspection and approval. That's the first thing the ALJ found. The ALJ secondly found that there was an injury as it's defined under the statute and that an accident had occurred as it's defined. Therefore, again, Schindler had a duty to follow laws and rules and not release the equipment. And that's purely what's at issue here. They released the equipment because not only did the facility owner file an accident report and TDLR accept it within the time period they were supposed to, but they were told not to release the equipment back into service. So they did it anyways. That's clearly a breach of what their duty was under laws and rules.
Are incident and accident synonymous? When you say incident, accident report, are they two separate reports?
No, the actual, I have it right here if you guys want to see it, but the incident/accident report is titled as incident.
Okay, but when it's filed, it's known that it's an accident report being filed with the
Yes,
department.
that would be the only reason why you would be filing it. So I don't want to jump into conclusions for RPM, but they act as synonyms from my understanding of their procedures.
And when they stopped the service, it got inspected, but they just didn't inform TDLR they were open, or they didn't get permission from TDLR, or they didn't inspect?
The equipment was not inspected.
So neither
The fir-
inspection, they repaired
Right.
it.
They repaired it and
but
then they
not-
placed it back into
okay,
service.
But not inspected or?
But it was not inspected, and no one had told the department that it had been placed back into service and that it was okay.
Mr. Chairman, that is just not true. We did not repair anything. It wasn't broken. The escalator worked exactly like it was supposed to. It prevented that child's arm from coming off. There was no repair done at all. So it's just not tracked. The actual handrail inlet that was on that job beforehand is still there. No repairs at all.
But the handrail inlet had to be cut, so
That is not true. Absolutely not true. 4 screws, take it out.
Yes, sir.
Yes.
State your name.
Jim Renan, Chief Elevator Inspector with the State of Texas. So at the time that this incident report was filed, I was out on the road. I had my deputy chief contact Schindler up in Dallas. That's how we found out that the equipment was back in service, and he was explicitly told by the Schindler Dallas office that the handrail inlet boot, that's a rubber boot that goes around the handrail, had been changed. What Robin's trying to tell you is we receive an incident report. It's then TDLR's decision to determine whether that's an accident or it stays an incident. From the information we had on the report, there was only one way I could rule that it was an accident. Once it is an accident, the equipment has to stay shut down until, and preserved as much as possible. The rules specifically state the equipment can be moved if it's moved to extricate a stuck person. So when this child's hand originally got stuck, and it says right on the report, they called the Dallas Fire Department. They had to pry this young child's hand out of the inlet switch.
Jim, is that in the
Yes, it is in the
record?
record.
Yes.
Okay.
And then on the report, it states that his hand was bruised and there was blood around his fingers. I can't see myself ruling this any other way. I'm sorry, not with a 5-year-old child. Mr. Taylor is correct that an incident, and one point, not all incident reports require an inspection. We do that once it's ruled as an accident. He is correct. This child hurt himself. It was not due to an equipment malfunction, but the fact still remains that we ruled it an accident, and in that case, the licensed contractor has to leave the equipment shut down.
When did the Schindler get notified that they would have to be inspected for, when were they notified of that? They had to get inspected before they went back to operation?
It's right here, Rob. It was on June 13th of 2017.
No, it was before that. That's in Jared's notes.
Put it back in service on June 9th.
They put it back into service on June 9th, but they were told, prior to that, June 5th, I believe.
No, 6th.
June 5th. Yeah, the store
We
manager.
ruled it
Got
an
it.
accident.
Okay.
I have.
Any other questions?
Yeah, do we have any prior violations by Schindler?
I don't believe we have any prior violations. I'm trying to remember. I know I've seen other cases. I'm just trying to remember.
The record
There's
itself
no-
shows that there's been no problems, right into AALOJ's report.
Okay, and what
About
is-
the only thing he got right, by the way.
Okay, what is the range of punishment?
For the elevator program for a Class C, it's a range of $1,000 to $5,000.
And we jumped 3?
So we chose 3. 3 is in the middle of the range.
For the
And
first time?
Well, so I've actually worked several elevator incident cases, accident cases, and due to facts and nature of the injuries and the facts at hand, we felt going in the middle of the range was sufficient.
Was there any permanent damage to the child?
We don't have that information.
Okay.
Any other questions?
Can I make a motion?
Hang on, let me see if there's any other
Yeah,
questions.
so, when you called the corporate office in Dallas, they indicated that, something had been replaced, is that correct, or?
Yes, ma'am.
Okay.
Yes, that the handrail inlet boot had been changed.
Mm-hmm.
My deputy instructed them to shut the equipment back off, and we were told that they had reinstalled the old boot, was what the supervisor
Okay,
told
and you
us.
have the date and time when that conversation took place?
That was on June 13th.
Okay.
Since then, have we had a full inspection of the,
Yes, ma'am.
okay, and I'm assuming it passed?
Yes.
Okay.
Any other comments? I know Commissioner Yurko has. Any other?
Yeah, and no other incidents or anything since it's passed? Nothing's been reported?
No, in fact, the inspection that took place, there was no violations noted, and like I said, the accident did not involve equipment malfunction, so.
I just have one comment. I can appreciate the definition of the accident being a serious bodily injury, and it happening to your fingers, extremities that are farthest away from your heart or something vital, and just the pure definition, even though it's horrible what happened to a little child. I can appreciate that it wasn't an accident, but we don't want to deter Schindler or any other companies in the future to report what could be potential accidents just because. So I commend you for reporting it, whether it fit the definition of an accident or incident. But as soon as that happens, as soon as you report it, you have to know you're following department guidelines, and you have to say, okay, we have to have an inspection if we're reporting
Well,
something.
I'm glad you said that, Mr. Commissioner, because an inspection as required by TDLR's own rules did not occur. The rules themselves require a representative of TDLR to go do it, and they abdicated their responsibility to do that. 7469 says until an inspection by a representative of the department, and a licensee of this department cannot be a representative. Only TDLR employees are a part of that, and the definition of TDLR, of department, is the Texas Department of Licensing and Regulation. So to this day, a compliant inspection by a TDLR employee has still not taken place.
But in the elevator program, elevator inspectors are, in a way, a representative of the department because they do report back on inspection forms, different violations that have occurred while they're doing their inspections. We have several other programs that follow the exact same protocol.
Correct.
Any other comments?
Yeah.
Mr. Taylor, thank you so much. Make sure you fill that form, Mark, please. Thank you. All right.
Okay.
You have a motion?
Yes, I'm going to make this motion based truly on Schindler's reputation and the fact that this injury, while it could have been dangerous, ultimately was a minor injury to the child. Ultimately, but we do need to follow the rules of having the complete inspection process and do need to send that message. I'm going to move to adopt the PFD, but to modify the penalty to $1,000.
Is there a second?
And I believe that would require the conclusion of law to be
Number 17.
number 17 to be,
Right.
to reflect that as well.
Right, and I second that.
Okay, any discussion? All right. All in favor, say aye.
Aye.
Opposed? Motion
Thank you
carries.
guys very much.
Yeah,
Thank
thank
you,
you, Mr. Taylor. Yep.
Thank you again. Don't forget the form. Robin, thank you. Thank you, sir. All right, Mr. Delgado. Mr. Delgado? I don't think I have it.
Concise and clear.
Okay. And Sharp. Okay.
Mr. Chairman,
Yes, sir.
how's the commission doing? Do we need to take a break?
Okay.
We're getting ready to start a new
Okay,
series.
actually, why don't we do that? Why don't we take a 5-minute bio break?
Yes.
Give us a minute, if you don't mind, Mr. Delgado.
Yes, Brad is here.
You coming up next?
Yes, sir.
Mr. Chairman, good morning, Commissioners. My name is Ken Sharp. I'm a prosecutor with the Enforcement Division here at TDLR. I'm presenting this case on behalf of Prosecutor Trevor Thielen, who represented the department all through all stages of the proceedings up through SOA, and he wasn't able to be here today, so I'm here on his behalf. The respondent is Jose Delgado, and the administrative law judge wrote a PFD that suggests that you revoke Mr. Delgado's journeyman electrician license. Mr. Delgado has been licensed since 2005. In 2015, when he was 43 years old, he was working on the job site at a school with a co-worker in San Antonio, and both men were providing electrical services at that time. Apparently, the co-worker would not allow Mr. Delgado to use some of the copper wiring that he needed, and the co-worker told police that Mr. Delgado stabbed him in the face with a pair of needle-nose pliers, and that the pliers went into his nostril and just below his eye, and then puncturing his face, causing him to bleed, after which Mr. Delgado began to choke the victim. And at the hearing, Mr. Delgado testified that the victim's injuries happened unintentionally, that his pliers had been in the pocket of his work vest when he had grabbed the victim and put him in a headlock. And the police did find blood on Mr. Delgado's work vest and the pliers in his vest pocket. And they also found a pocket knife on his person. Mr. Delgado ultimately pled guilty to exhibiting the pocket knife and threatening to stab the victim, the co-worker, or stab and cut him. In January of 2017, Mr. Delgado was placed on deferred adjudication community supervision for 3 years. Now, 10 months later, in that same year, he applied to renew his license. And despite still being on probation and having pled the case earlier in the year, Mr. Delgado falsely answered no to the question on the renewal application that asked if he had been convicted or placed on deferred adjudication since his last license had been issued. He testified that he did not falsify his application on purpose and only made a mistake because he had been completing the application late at night and he was tired. However, the timestamp on the online application that he submitted to the department indicated it was submitted at 12:20 p.m. in the middle of the day. The ALJ found that the applicant knowingly falsified the application. The ALJ recommends that you revoke for a few reasons. The first is the false answer on the application. The second is the fact that the offenses were directly related to the occupation because a crime against a person is one of the guideline crimes. The offense is also directly related to electrical work in this particular case because it happened at an electrical job work site. It happened against an electrician co-worker, and it was while he was performing his electrician job, and it was over materials. The argument was over materials to be used as an electrician, and apparently there was an injury that occurred with that electrician's tool. The third reason is that the evidence shows the respondent does not currently have the honesty, trustworthiness, and integrity required to hold an electrician license. Now, the respondent was an adult when he committed the offense, and that was less than 4 years ago, and he's been on probation now for 2 of the 3-year probation period that the court put him on. The ALJ concluded that Mr. Delgado needs more time to show that he will not reoffend, and to show that he does have the fitness and the honesty, integrity, and trustworthiness to hold the license. The department recommends that you adopt the PFD as written, but with one minor technical correction to it. On finding of fact number 9 on page 9, the ALJ said the hearing occurred on September 24th of 2018, but the hearing actually took place on September 25th. It's a minor technical thing, and we recommend that you change that date, and with that change, adopt a proposal for decision.
Okay. Any questions for Mr. Sharp? All right, Mr. Delgado, state your name again. We have to stay within what was presented at the SOA hearing, okay? So we appreciate that.
Yes, sir. Good morning. My name is Jose Delgado. I've been a construction worker for more than 25 years, 14 with the license, journeyman license, and 25 years in the electrical field, construction. I just wanted to say, and first of all, I wanted to tell you thank you for having me here and giving me the opportunity to speak. I just wanted to say that a lot of programs that you guys have now, TDLR, they're very good. Another one that I want to bring up is earlier today, people were saying about different licenses and careers and work that people do out there. And it'll be good. It's going to be a good thing if you guys kind of bring a program where you can implement it to construction workers. We do work under stress, under pressure sometimes, and we have to meet these goals, time frame to finish up projects. And this is not an excuse. This is just an example of what happened out there in the real world doing construction. And I just wanted to say that a lot of these things that they stated, about me, what happened today, it's not true. It's not true because I didn't expose no knife. We do use knives, we do use pliers, all kinds of electrical tools. Yes, I have my tools in my pocket, which I didn't actually took my pliers to stop the guy. And the statement that Mr. Trevor, prosecutor, brought it last year to downtown meeting, he stated that I stopped the person. I didn't stop the person. I guess the translation that they got from the public records in Bexar County, they mistranslate that. I didn't stop nobody. And you can actually see that in the judgment indictment and actually in San Antonio. So first mistake right there.
I'm sorry?
Is that confirmed?
I'm looking at it right now at the indictment. I do know the deferred adjudication, he pled nolo contendere to the charge of aggravated assault with a deadly weapon, and is my understanding that would have been based on the brandishing the knife and threatening to cut and stab the victim. That's what that was based on, but, I'm sorry.
No, go ahead and finish your thought, then I want to say something.
I was just going to say, I'm looking at the indictment now, and it has 2 parts. The first part, count 1, is that part about threatening to cut and stab the complainant, and then the second part has the part about the pliers. It was the first part that he pled nolo contendere to, and the second part was dismissed as part of the plea bargain.
Yeah, because I didn't see where it said he pled guilty, because that's why I was confused by the pleadings. It says pled guilty or nolo contendere. It's really not an or, it's a one. So what was it? Did he plead guilty or did he plead nolo contendere?
Nolo contendere.
Okay, because that's a big difference.
It is.
Okay.
Because then it's a strategy thing, what you're trying to deal with,
Okay. All right. Mr. Delgado, you can.
And as I was saying, I didn't agree with the statement that Mr. Trevor did that morning. So he changed it right there and there because I actually told the judge that I didn't stop nobody. The guy got hurt with the tools that I have in my pocket. This is what we do most of the time, or sometimes when we are actually going for material real quick to the container. Sometimes we do have pliers to cut wire with, so we just stack them in the pocket. So I'm not gonna say I didn't do it. I did admit it before the judge. Yes, I pushed the guy aside, but I didn't actually pull out my knife or my pliers to stop the guy. Besides that, just want you to know that the license, as you know, is very important to me. And to anybody that is holding a license out there, it's actually what I used to work every day, to do what I love to do. So I just want to continue being part of the construction and put my part in the construction. This is what I like to do. This is what I hope, if you guys give me the opportunity to hold my license, keep on doing. Thank you.
Thanks for showing up. Appreciate that. Any questions? Mr. Legato, Mr. Sharp. All right. Any ideas on a motion?
Question, on, let's see, you did present reference letters?
Yes.
Who do they come from and how many?
Presented 3 from a coworker that I was working before I got this accident. They prevented me from work last year in September, and Moses Gonzalez, and my wife, and can't remember the name.
Is that in the?
It is, it's right here.
I don't know if you had it.
Oh, AJ Mazzarella, that's HR for the company that I'm working.
Your
Yeah.
company, okay. And then you completed an anger management course?
Yes, ma'am.
And did you pay for that course or the company?
I pay for that course.
And how long was that training?
The class, that was 8 hours.
Sharp, any other incidences?
Not that I know of, Mr. Chairman.
Any more discussion, questions?
Brad, did you give us an,
No.
is there one? Where we can possibly still keep the revocation but move to
Probate the
probate,
revocation
suspend or
orders.
probate it? Because I don't want to come back here if we have another incident with this gentleman. Do you understand what I'm saying?
I do. You have that, full range of options. The action to take in this case is within the commission's discretion. So if
You can
you
probate,
think-
suspend, or revoke.
Right.
Or those things.
Right. And a suspension could either be fully served or it could be probated, meaning
Right.
with terms and conditions, and if you violated
Right.
that, then the license, the suspension would be served at that point, or it could be a mix of fully served suspension and probated suspension. So there's a range of options
Sure.
there for you.
Mr. Delgado, what I'm getting at is, I do understand that by the judge allowing you to plead to a nolo contender rather than a guilty plea, that does speak somewhat, a little bit of a difference to your situation. And what I'm going to propose is a motion, is to still adopt the revocation of your license. So if you do not stay straight and slip into the anger issues, your license will be immediately revoked, but that we're giving you a chance to have it probated so you can continue to work and provide for your family. But it's a one-shot deal.
I understand,
You won't be
ma'am.
coming back before us and try to plead and get a second chance. It will just be revoked.
I understand, ma'am. Thank you.
So, and that
Are you
would,
making a motion on it?
that would be my motion that I'm actually making, is to move to adopt the PFD, but to amend it to probate the revocation.
You could do that.
Okay.
I did want to clarify one thing, Mr. Chairman. The revocation would not be truly automatic. The department would have to take some action based on information that
Conditions.
we
Correct.
learned of violating the conditions of the probation. And then you'd need to set a term for that probation. Is it 1 year?
Yeah, because the
And how long is his,
the 2020 community supervision.
right.
Is it January 2020, Mr. Sharp?
I think that's it. It's about a
Yes.
little less than a year. Just.
Okay, so can we get it to, is that reasonable to, Mr. Sharp, for us to mirror it with his community supervision, that time period?
Well, first of all, it's your decision to make on
No,
that.
no,
but-
do we have the
but
feasibility, not?
You have the
yes.
authority to do that. and-
Okay,
and
then
to-
that's
to
what
match
I
that right
would
up.
propose.
Yeah.
Okay.
So I want to get to the heart of
Yes,
your-
sir.
So you want to, instead of revoke, you want to probate the sentence in concurrent with his probationary status of 2020. Adopt a PFD, but just probate
No,
it.
it would be revoked.
Be
but-
revoked.
But it would be, the revocation would be probated, that means.
Right, okay, got it. Want to make sure, that's your motion.
Yes.
Is there,
And just to confirm, there's been no other reported incidents?
yes, I asked.
Okay, sorry, I didn't, yeah.
Do we have to state that, the revocation's based on the next incident or based on a conviction? Do we have to state that in the proposal?
I think the PFD already covers the
Right.
legal basis
Okay.
for to support the action, so I think it's there already.
Mr. Garza, it's as if that revocation is still hanging over him until such time that the probation period's completed.
Is there a second to?
Yeah,
Commissioner?
yeah, just to make it clear, repeat it. Sounds like.
Probate the revocation in concurrent with his probationary step 2020,
Right.
January 2020. That's
Yeah.
what she's proposing.
And I-
So amending the PFD except
Right.
with that.
Got it, then I'll second that.
Okay.
I'll
And
second.
please be sure when you do your, I'm going to assume you're going to keep your nose clean and you're going to actually complete it. But when you do your renewal, you're going to be really honest with that application.
I was gonna ask you a question. I did the renewal, thinking that the need of me working, it's in the department TDLR, it's pending, I guess it's pending. I just submit the 4 hours continuing education and the fee and everything else.
Right.
And I'm just waiting for something like
And
that.
if you ever have any question about, do I include this deferred adjudication? Call and ask. Make sure you include it.
Okay.
Okay?
Okay, thank you.
Any other, okay, so we got a motion.
So,
second. Any
before you
discussion?
do that, can I say one more thing about the period of the probated suspension, or revocation? If you tie it to the period of community supervision, would you want it to terminate if he gets a termination early? Sometimes they'll say, well, you've done 2/3 of your community supervision and haven't had any problems, or, they'll let him off a couple of months early, something like that. Or do you want it for the specified period, January 2020?
Why don't we complete it to January 2020?
Okay.
You still got the second?
Yeah, I still have the second. I mean, if there's any issues where he's not complying with community supervision, then I,
Yeah. Yeah.
All right, any other further
I second
discussion?
it still.
I think, just based on that, would you make complying with the conditions of probation a condition of the probated revocation?
Correct.
Right. Did you get all that, Brad?
I think so.
All right. You sure?
what
I
do we
can't
say?
repeat it.
That's what I said.
I think we got it.
All right.
You'll see when it comes across your
All
signature.
right. No more discussion. All those in favor say aye.
Aye.
Opposed? All right, still got it. You've been given a second chance. Highly advise you use it.
I understand, sir, thank you.
Motion
I
carried.
had circled it.
Any questions?
Appreciate it.
All right. Redding, Mr. Redding. Is he here? I guess not, I don't have a form. So. Ms. Sharp, you doing this one?
Yes, sir. I'm, for all practical intents and
have a
purposes. Well, I don't know these.
All right.
The other one was a prototype, it was an experiment, and if,
Good luck, by the way. They're all looking at your timeline.
okay, good. Well, then, in the future, I'll try to get those out and with my cases. I think they're a little bit more,
We're all becoming 90s.
Be so lucky.
in fact, I may even get socks with timelines on them.
We'll make sure she's medicated. ADD.
We love socks.
All right, go ahead, Ms. Sharp.
All right. Again, my name is Ken Sharp. I'm a prosecutor with the Enforcement Division, and I'm presenting this case on behalf of Trevor Thielen, who represented the department through the SOA proceedings and prepared this presentation for you. The licensed applicant in this case is John Michael Redding. The administrative law judge recommends that you deny his application for an apprentice electrician license. In 2002, at age 30, Mr. Redding committed 3 counts of indecency with a child. 2 of the counts involved him exposing himself to his twin and 12-year-old stepdaughters, and the final count involved him touching the genitals of his 12-year-old. Mr. Redding admitted to the police that he had watched about 10 pornographic movies with the children in the past year and had touched the genitals of one of the children 10 to 12 times as well. In 2003, Mr. Redding pled guilty to all 3 counts and was sentenced to prison. He was released on parole in October 2017. His parole supervision is currently scheduled to terminate in 2021. 5 months after he was released, Mr. Redding applied for an electrician license. And at the hearing, he told the ALJ that he now holds a full-time job that does not require an electrician license, but he's only seeking to work in industrial settings, and he wants the license for that. However, an apprentice electrician license would allow him to work anywhere in the state of Texas under any circumstances where they use electricity, of course, and that would include schools, businesses, daycares, anything like that. The administrative law judge recommends that you deny the license application because crimes involving prohibited sexual conduct or those committed against children, as well as crimes against the person generally, are directly related to the electrician occupation. The ALJ found that these offenses were very serious and noted that the applicant provided no letters of recommendation, no documentation showing any kind of rehabilitation, either while he was in prison or after he was released. And not enough time has passed since his release for him to have established a good record of conduct and demonstrate that he holds the honesty, trustworthiness, and integrity to hold an electrician license. The department recommends that you adopt the proposal for decision as written and deny the license.
All right, thank you, Ms. Sharp. Any comments from Ms. Sharp? Questions?
Yep.
Motion?
Move that we adopt the PFD as written.
Second.
All right. Any discussion? All those in favor, say aye.
Aye.
Opposed? Thank you, Ms. Sharp. Mr. Tim Warriors.
Mr. Chairman?
Yes, sir.
Sorry, could we repeat who did the second on that last motion?
Mr. West.
Okay, thank you very much.
I'm here to help. Mr. Warriors, okay. Ms. Sharp, go ahead.
For the record, Ken Sharp, prosecutor with the Enforcement Division, and I'm presenting this case on behalf of Trevor Thielen, who handled the case at SOA and prepared this presentation. The respondent is Timothy Moyer. The administrative law judge recommends that you revoke Mr. Moyer's electrical contractor license and that you deny the renewal application for his master electrician license and revoke that master electrician license as well. Mr. Moyers has held both licenses since 2010. In 2016, when he was 45 years old, he talked online with a 16-year-old girl who lived 3 houses away from his house, asking her for oral sex and sexual intercourse. He requested and received nude photos of the girl, and he also sent her nude photos of himself. According to the police report, in his text messages, he told the girl that they could have sex, quote, all the time, end quote, if she were his stepdaughter, and told her that he would even have sex with her if she were even just 11 years old. In 2017, he pled guilty to criminal solicitation of a minor and was sentenced to 10 years in prison. However, the court suspended that sentence and placed him on a 10-year period of community supervision. The administrative law judge noted that the respondent presented supportive letters from his sex offender treatment counselor and probation officer and character witnesses, as well as forms showing he had disclosed his sex offender status to some of his customers. After considering all the evidence and Mr. Moyer's expressions of remorse for the offense, the ALJ nevertheless concluded that the conviction was still so recent that a good track record of good conduct, and a fitness to hold an electrician license could not have been established at this time. He recommended that the licenses be revoked and that the renewal be denied because the offenses were directly related to the occupation of an electrician. As a crime, these are crimes that involve prohibited sexual conduct and involve children as victims, or a child as a victim. And then also because the evidence in this case showed that the respondent lacked the honesty, trustworthiness, and integrity and fitness to hold an electrician license. The department recommends that you adopt the PFD as written with a few minor technical corrections to it so that we use the right terminology for the name of the licenses. We just want the record to be accurate. In finding of fact number 14 on page 7, the ALJ said the hearing occurred on September 24th of 2018, but it was actually on September 25th of 2015, and we recommend that you correct that date. On page 6 in the analysis section, the PFD reads electrical, or should read electrical contractor license and not, as it does, electrical contract license. Also on page 6 in finding of fact number 2, it should read licensed as an electrical contractor, not licensed as a contract electrician. And then on page 8, in conclusion of law number 11, it should read electrical contractor license and not contract electrician license. And with those technical corrections, we would ask that you adopt the PFD.
Any questions for Sharp? Ms. Moore, again, say it again, contain it to what was so hearing, if you don't mind.
Sure.
State your name for the record, please.
My name is Timothy Lynn Moyers. As I stated in court and at trial to the judge, it's on record, I actually thought she was older. I thought she was 17. I did make the comments that you heard. The only one I did not make, but I did not get to defend myself in court for, was the 11-year-old statement. That was taken out of context because they had pulled the messages off of 2 phones. I presented a number of recommendation letters from people that I work for that my probation officer is in there. He has seen me since July of 2016. He sees me 4 times a month. I am subjected to polygraph testing. I am currently in a offender program where you have to go every week and you have to fill out forms at the end of the month, and you're subjected to polygraph testing over those forms. The judge gave me 10 years in prison. He probated it. He told me you're going to get 90 days in jail with work release. I spent 90 days in jail with work release. That was my sentence in jail. I got out, started my program for the sex offender registry, and as you can see from the form, my doctor says that I'm moving forward, performing well, I have no violations. I just throw myself at the mercy of the commission. I have been an electrician since 1990. I had a license before the state issued license as a journeyman. I was in one of the first cities that was ever licensed as an electrician. So I just wanted to correct that. I haven't been an electrician just since 2010. I've been an electrician most of my life. This is my sole means of income. I would ask that the commission consider probating it against me, giving me a chance to prove that I am doing what's right. And I mean, I'm under, you don't have to watch me, I am watched. I have offender registry, I have probation officers that watch me, and I have sex offender doctors that watch me.
Anything else? Sir. Okay. Thank you, Mr. Morris, for showing up. Appreciate you being in front of us.
Thank you.
Tough.
I just want to clarify one thing, if I may. It's just these 2 licenses that we're talking about that he's held since 2010. We didn't go into his license history before that.
Okay.
Just
Got it. It really needs that. Good. Thank you. Thank you for that correction. All right, discussion. Any questions? Commissioner?
Interesting. You mentioned you thought she was 17 years old?
Yes.
Isn't that also a minor?
No, not in the state of Texas. I actually thought she was closer to 18. My daughter and her went to college or high school together. My daughter graduated. I worked for the school district, and she was in high school with my daughter, okay? And like they said, it was 3 houses down from me. I had committed a moral sin against my wife in my mind. I did not believe I was creating a criminal. Did not believe I was creating a criminal offense. I pled guilty to keep her from being drugged into court and dragged through by my lawyer. I said, look, if the judge will work with me, I'll take the plea, because I don't want you taking her to court and dragging her into court and making her a bigger victim than I've already made her. That's not my intention.
I'm not sure that was in the record. I don't have any,
Right.
I don't see any evidence of that being in the record.
Any comments? Any questions?
Until, on community supervision until when?
I think 2027 is the date. Yes, 2027.
And it began when, supervision?
In 2017, when he pled to the charge. And just to clarify, because I know you probably haven't had to work with these before, but what we're proposing at this time is revocation for this time, at this time. And in the future, you know, if he shows that he develops that good record of conduct and shows that he's complied with all those things, we would look at this again for a future application. It's just right now, not forever.
I just don't believe I'll get any better report from my doctor than what I'm getting. I mean, this woman deals with us, with offenders, daily. This is her specialty. She's actually recognized by the state as one of the premier sex offender registry caseworkers.
We'll just address if there's a question to you, we'll get it to you. Okay?
Sorry.
That's okay.
Mr. Chairman?
Yes, sir.
I'm wondering if the community supervision requires that offender treatment and that the reporting stays the same throughout the 10 years, or does it graduate off? Does it increase?
I'm not sure.
Yeah, I think we need to understand that, make sure that the terms are consistently stringent throughout that time period, as opposed to it starts off tough and then gets lighter, so I don't know.
I can tell you from what I've been told now, and you can check this, which I would hope you would. You have the ability after about 5 years to complete the course but remain a registered offender, meaning that since I'm on probation, I have to still subject to polygraph. I still have to go to meetings once a month, not 4 times a month, but I'm never allowed not to be there at least once a month, and I'm never allowed not to be on polygraph. The law says I have to be polygraphed once a year. They can polygraph me every week of every month if they want to, if they have a reason to. I have passed all of my polygraphs, and that's, I believe you've got that in the record that I've took.
It wouldn't be in the record because polygraph results are not admissible.
Okay, so it's not.
Well, I mean, I think she wrote it in her letter.
Any other comments?
As far as the conditions of the community supervision for the criminal charge, they remain the same as ordered by the judge for the duration of the period of community supervision.
They do remain the same. They don't taper off.
Now, having said that, the supervision officer can adjust the reporting frequency from, say, once every week or once every 2 weeks or once a month, as the reporting or the community supervising officer deems appropriate.
Mr. Moyer, I commend you for all the work you put into this and your attitude. I think that is wonderful. I will be honest, for myself personally, I can't speak for anybody else here, I don't think there's a sufficient amount of time to demonstrate an entitlement for this license at this point. It's just the ability for the Texas Department of Licensing Regulation to give you a license to go into other citizens' homes in the state of Texas and to just certify that you can go in there and that we're giving you that stamp of approval, I just don't think is fair to other electricians that carry that same license right now. And I encourage you to keep forward on that work, and I can't tell you how everyone else is going to vote, but I just encourage you to keep forward with what you're doing.
The other thing is, I don't know if you noticed, I have to tell everyone that I enters home that I am a sex offender, that I'm a registered sex offender. That's part of my deal, and I have included the letters where I do that. I do religiously.
Okay.
Religiously.
I'm going to take my hat off, Mr. Morris, and tell you that my bogey, and I've said this many times, is I got to feel comfortable you walking in my house with my kids alone. I can't, you know, that's my bogey. It's a rock and a hard place. A man's ability to work is but you, in my opinion, put you here.
Sure.
Right, so, but we have to kind of walk through this. And I'll tell you, Commissioner Errico's comments are spot on. This is going to be a journey. It's not a point. It's a journey. And so that journey is going to have to continue in my eyes and for a little longer. But I would tell you, I appreciate you being here and taking what you took. I don't appreciate what you did, and I don't appreciate the conditions that you put us all in to have to deal with. Your family's responsible. You're responsible for your family. And I'm sure you've heard that many times, but I'll tell you that the bar is high. us to allow that to happen.
Can I ask how long before I can reapply?
It'd be if we decide to adopt the PFD, it would be.
There's a 1 year
1 year,
waiting
1 year,
period
1 year.
before he would be eligible to reapply.
This
And
is
then
my
at that
opinion,
point,
this is again.
at that point, it would be then discretionary with the agency. It's not a guarantee at the 1 year, but.
Any other comments? All right. Motion?
Move to adopt the PFD as written.
Mr. Chairman, I'm sorry, the technical corrections.
Oh,
and
I'm sorry. I
New
meant
ones,
to
like
include that,
several
yes.
of them.
I wanna
We have
make
to go
sure
through each
we-
one, can we just?
Could we go back through them just to make sure we?
Okay, and to adopt, to modify finding of fact number 2, to read licensed as an electrical contractor, to modify finding of fact number 14, to read the hearing date September 25th and not September 24th, and to modify conclusion of law number 11 to reference electrical contractor license.
Did we get, Ken, did we get everything? Was that?
That was.
There was a reference in the analysis on page 6 to that same electrical contract.
And to make it consistent on, right.
And
Thank
you had the
you.
motion
I
with
did.
our top 50, is there a second? I don't remember.
I think there was-
Joel get a second. All right, any other for discussion? All those in favor say aye.
Aye.
Opposed? Moyer, your life's a testimony. My hope is that it's a positive one.
Appreciate that.
Yours.
Mr. Chairman, we'll have someone from the Enforcement Division.
Yes, I'm sorry, and this isn't your
Linda.
last stop, he'll walk you through the next steps. All right. Thank you, I need
Thanks,
to,
sir.
appreciate that, Brian. All right, Mr. Tolliver. Sharp, are you doing this one? Getting a volume discount from me today?
Yes, sir.
All right. All right.
Do you see his stack?
No.
I think we should charge him by the hour.
I have another handout here. This is not like the other one, but this is something that's a whole lot more stuff than I wanted to say that would probably be easy for you to read.
Isn't that a Sesame Street?
Are you
Isn't that a
watching?
Sesame Street song?
No, oh,
Which
I-
one of these is not like the other?
Oh, I don't know, that might be.
It was the conjunction bunch and whatever.
All right, guys, I know you're hitting Looneyville, we're gonna get through this. All right, Ms. Sharp, what you?
Sadly, all those things came along after I grew up, so.
Yeah.
Ah.
Oh, man. Making me feel old.
All right. Sharp, go ahead.
Thank you, Mr. Chairman. Ken Sharp, prosecutor with the Enforcement Division. I'm presenting this case on behalf of Trevor Thielen, who handled the case all the way through the SOA proceedings and prepared this presentation. The respondent is Ben A. Tolliver. Mr. Tolliver has been licensed since 2014. 2 months after receiving his license, when he was 20 years old, he went with a male friend of his to the home of a 15-year-old girl. The girl wore an ankle bracelet monitor, and her mother, who worked nights, was not around at the time. The two men took the girl to a park in College Station where they both had sex with her. The police received calls from people in the park who said they saw the female having sex with one of the males while the other appeared to be taking a video or maybe photos with his phone. The police arrived and eventually they took all three into custody. And at the police station, the girl admitted that she was 15 years old and she told the police that she did not consent to have the sex, that she said she was forcibly raped by the two men. Mr. Tolliver admitted to the police that he had sex with a girl, which constitutes sexual assault of a child, even if she had consented, because she's a minor and by law cannot consent. And of course, at that age, we understand why. In 2017, he made a deal to plead the case down to a less common offense: enticing, persuading, or taking a child from the custody of their parent or guardian with the intent to commit a felony, the felony being a sexual assault of a child. The offense was still a felony, so the court placed the respondent on community supervision, deferred adjudication for 10 years. And he's still on probation, at least according to his testimony at the hearing. In 2018, the respondent applied to renew his license, and despite still being on probation and having pled the case less than a year earlier, the respondent falsely answered no to that question on the application that asks whether he'd been placed on deferred adjudication or convicted since his last license was issued. He testified that giving the false answer was an honest mistake, but the ALJ did not believe his testimony and concluded the respondent knowingly made a material misstatement on the application. Despite the evidence proving the plea and the circumstances surrounding the case, despite concluding that the respondent's crime was serious and that his license could be revoked for it, and despite concluding that the respondent knowingly gave a false answer on his application, the ALJ concluded that the preponderance of the evidence did not prove the respondent's license should be revoked. The department filed, Mr. Thielen filed exceptions, and he pointed out, first, the ALJ had mistakenly thought that the girl was 16 years old instead of 15, and I don't think that would have made any difference, but that was a mistake. The ALJ made no reference to whether this was a forcible rape against the child's wishes. The ALJ inappropriately focused on the fact that the child initially lied about her age while in the presence of the male who she later disclosed had just raped her. The ALJ found the respondent knowingly falsified his application, which must mean that the ALJ believes the respondent intentionally lied under oath at the hearing when he claimed it was simply an honest mistake. Incredibly, the ALJ still concluded that he is fit to hold a license despite those things. After the exceptions, the ALJ corrected the age of the victim in the PFD, but did not address the other needed corrections pointed out to him in the exceptions. Instead, the ALJ simply urged the Commission to, and to quote, thoroughly read staff report, or Staff Exhibit D, the College Station Police Department report, end of quote. And if you read the report, you can see the victim's statements to police where she said that the respondent had forcibly raped her against her will. And if you read the report, we believe you'll find that the respondent's behavior was unacceptable for a licensee whose work may bring him into contact with underage females. Because of the offense he committed, because he lied on his application, and because he lied a second time under oath about the first lie, the department recommends that you revoke, or that you reject the PFD and revoke the respondent's license. And if you'll find it helpful, I've given you a copy of the language that Mr. Thielen put in his exceptions, asking the administrative law judge to change his PFD. And if you choose to use that language, Mr. Thielen recommends that you delete one sentence from that exception, and that's the one that's stricken after paragraph 2, or at the end of paragraph 2. And I can go into those with you, but I think it's pretty self-explanatory. It's probably easier for you to read those. But with that, the department asks you to reject the PFD and to revoke the respondent's license. Thank you.
Okay. Any questions for Mr. Sharp?
Remind me, what did SOA order? Because this kind of goes back and forth. So what was SOA's order?
It does. The PFD recommended that he be allowed to keep the license.
That's it?
Yes.
Okay. Any other questions? Mr. Tolliver?
No probation, nothing, just allowed to keep the license?
I don't think so. You know, I'm going to double check on that, but just to make sure. But as I understood it, it was just a non-revocation. That's all it was. In conclusion of law number 13, it's, the PFD says the commission should not revoke respondent's apprentice electrician license.
Okay. Any other questions? Mr. Tolliver, contain your comments to the SOA hearing, please, and state your name for the record, please.
Ben Tolliver speaking, and referring to the renewal application, it was just an honest mistake. It's kind of repetitive every year. You know, you got to renew a form or whatever, and just the same questions over. So I just hurry up and fill it out and just try to get it over with. But besides that, I've been an electrician since 2014. I think October 17, 2014. And like you said, I called this case 2 months after I first started in the field. And so I just signed probation March 9th of 2017. So I've been on probation for 2 years already. I have recommendation letters from my probation officer that I abided by all the regulations, all the rules, everything that follows my probation or whatever.
That was in the record, Mr. Sharp.
I'm looking for that now. I didn't see him earlier, but that doesn't mean that.
I have copies.
I know, but it's got to be in the record here, so I just want to make sure. But continue on. Just we'll double check.
Yes, and I've got recommendation letters from my vice president, my supervisor, and my safety coordinator at my company, my current company right now. Recommendation letters also. And I've been on probation. I've been fighting this case since 2014. I just signed papers, probation, in 2017. So since 2014, I have not gotten in any trouble. Ever since I've been on probation, I have not gotten in any trouble. That's almost probably been about 4.5 years. And since then, I've been trying to do well. Being in this field, this is how I pay my bills. This is how I take care of my wife, my daughter. I got a 7-month-old daughter back there. And if you revoke my license, it's like I got to start over. I don't know any job that's going to pay me $20+ to take care of my family. And it just putting me in a repetitive cycle, then how am I going to take care of my family, you know? And that's kind of putting me in a bind. And I'm not registered as a sexual offender, so I don't feel like I'm in any danger of any child or anything. Like I said, I have a daughter back here. And if I was to be put to work at a school with minors, they will background check me. It's required that they have to background check you, and they will go furthermore than that.
You weren't required to
No, I'm not.
register as a sex offender?
I'm not a registered sex offender.
Interesting.
And like I say, I caught this case in 2014. It's 2019. It's been 5 years that I have not gotten in any trouble. No failed drug tests. I'm not a registered sex offender. Nothing.
Any comments or questions for Mr. Toller?
No other incidents past this 2014 offense?
No, not to our knowledge, there isn't.
Is that a reference letter right there from Motiva?
There was one that was submitted to the ALJ.
Is that the company he works for?
It's from Roy Johnson, Motiva Enterprises LLC.
That's my former engineer.
Okay.
Is that Motiva associated with Shell?
Yes.
Any questions? Any comments? We're back between a rock and a hard place.
Mm-hmm.
That's what we gotta do. That's what we do. So, motion? Or discussion about the motion? I want to talk about the NCAA tournament or something? Pick a topic?
What about those Yankees?
Whose bracket's already screwed?
I will tell you that,
Yeah, it's-
I understand your situation in the sense that you seem like you worked hard, but the incident's severe in its own, and I understand enforcement's desire. It's a high bar. I'll go back to that high bar, right? The ability for me to feel comfortable with you walking into my house, I can't do that unless I know I'm comfortable with mine. And to turn you loose in the state, that's a big deal. So I understand the concerns of enforcement. So I'm pondering this as well. I understand your ability to provide for your family, and your ability to provide is everything. It's a values base, and I get that. All that be as it may, right? We're not here because of what we did, right? Sharp, and none of us are here is because of what you did, right? So I don't want to lose sight of that, and that's imperative that you don't lose sight of that. So that was my 2 cents. Commissioners?
Yeah, this was tough. And I mean, you know that having a license is your livelihood, and you can make a great living with your license. So this one's a challenge here, and I can look to Mrs. Any other comments? Let me make sure.
There's 3 examples, by the way, that revoke probating. If you look on the second page.
This one.
The back page too.
There's 3 options here.
And can I say one thing real quick?
Sure.
When I came up here in Austin, I forgot what court I had went to in December. I think it was like early December. The judge granted that I should not get my license revoked also.
Yeah.
If it's not the ALJ judge or your criminal judge?
He's talking about the PFD.
He's talking about
PFD.
PFD.
Okay. Oh, yeah. Okay. I'm sorry. I didn't know if you were talking about a different judge. Yeah, I got you. We read that. Any comments? I need a starting point. Sure.
Oh, really?
Yeah.
I think Ms. Collier's going to take a stab at it.
All right.
Yeah, I mean, for me, it would be, for definitely looking to, even though that the PFD is for not revoking, I think that's not the direction that I'm willing to support. And the commission decides to suspend rather than revoke. Brett, walk me through the other option here.
I think you have, I think we had maybe talked about this somewhat in context of another case. I think you have a range of options. You could, from what the judge recommended of not revoking to revoking the license. In between, you could probate a revocation, you could suspend and probate the suspension, or you could have a combination of an actively served suspension and a probated suspension. So it's depending on the factors we're supposed to look at, the severity of the offense, the length of time, all of those things. It's really what you believe is the appropriate action to take here, and I guess couching all of this in, I'm here. I think you disagree with the reasoning of the administrative law judge in coming to some of these conclusions, and you're entitled to do that. And I can kind of walk you through. If you're going to do any of those other options, I would recommend changing finding of fact 28, conclusion of law 6, conclusion of law 7, and conclusion of law 13. Those all really relate to the fitness of the licensee to hold, the respondent to hold the license.
Okay, all right, so the motion would be to mirror the previous scenario, to revoke and with the probation, and then based on the finding of facts for 28, 6, 7, and 13. Conclusion of law, thank you.
And then the term, is it a one-year term, or are you wanting to match the period of the criminal probation?
I'm not sure, what's the term? of the
That was
program?
through 2027, was it correct?
It was.
Yeah.
Yeah.
Oh, take a shot at it.
Yeah, I'm okay for, for the 1 year.
Okay. So,
Don't ask me to repeat it, I'm not repeating.
okay.
And then with the conditions that, well, the standard condition is that he comply with laws and rules of the
Right.
department.
Complies with all the laws.
Yeah,
And then
because
also complies with the criminal probation.
Revocation with probation.
Yeah.
That's what we're doing, for 1 year. That's the motion.
That's
I want to
that's
make
the
sure I get it right. Motion on the floor, right?
Correct.
Okay, with findings of law 6, 7, 13. Okay. All right, is there a second?
Second.
Discussion. All right. All those in favor, say aye.
Aye.
Opposed? Stalder, one comment that I want you to understand, that when you fill out these applications, you don't get through it. This is not a let's get through it scenario. This is how we communicate. And you being in your industry, it's imperative that we don't treat these as let me get through it. So when you answer these questions, especially in the condition that you had in your history, there shouldn't be taken lightly in any regards, whether there is a history or not, but especially if you have a history. Am I clear?
Yes.
Yep.
Motion
Yep.
carried.
Go ahead. And Ms.
Email, call. I mean, my gosh, email's so easy with your generation.
All right.
All right. And Mr. Tolliver, it's my hope that I don't see you here again. The only way I want to see you here again is that you're getting an award for doing excellent work. That's it.
So my license will not be revoked?
It's someone with staff.
Somebody
will
with staff will get with you.
will
You've got some other- this isn't
explain
your
you
last
for
Okay.
that. And, I mean, because this is tough for your wife to be here and your baby. This is not a good scenario for you. So when you have your license, that's your livelihood, as you noted, and it provides you a good life. Take care of it.
Thank you.
It's an opportunity.
Staff will get with you. You have other options as well, but they'll explain to you what we just went through. Okay?
Thank you.
All right, have a great day.
You too.
All right, Mr. De La Garza. Mr. Sharp, we haven't seen you in a while.
Good to be back.
Wow. You want to come on, Commissioner? All right. Ms. Sharp, oh, wait, Hollis, right?
Yes, Clay
Okay.
Hollis.
Is he gonna, Mr. De La Garza gonna speak, or?
If y'all have questions for him,
Okay, I just need, if he does, he needs to fill out a form. Okay, well, if he does want to speak, he needs to fill out, but we can do it afterwards.
Okay,
Just
very good.
FYI. Okay. All right, Ms. Sharp.
Thank you, Mr. Chairman. For the record, again, Ken Sharp with the Enforcement Division, and for the record again, for the last time today, no doubt much to the relief of many, I'm appearing on this case on behalf of Trevor Thielen, who represented the department at the State Office of Administrative Hearings and up to this point, and prepared this presentation as well. The administrative law judge recommends that you revoke Luis de la Garza's hearing instrument fitter and dispenser license. In 2010, at age 53, Mr. de la Garza became licensed as a hearing instrument fitter and dispenser. That license was issued by the Department of State Health Services. I think I got those initials right, but anyway. Beginning in 2011, when he was 54, and lasting until 2013, when he was 55, Mr. de la Garza committed theft by a government contractor as a Medicaid provider from the Health and Human Services Commission and Superior Health Plan Incorporated. He eventually pled guilty in November 2016 and was convicted of felony theft of between $100,000 and $200,000. The court sentenced him to 10 years in prison, but suspended the sentence and placed him on probation for 10 years. The court also ordered him to pay back $150,000 to those two entities, and as of the date of the hearing, he still had an unpaid balance of $100,000. TDLR began its regulation of the hearing instrument fitters and dispensers program in October of 2016 and started investigating the respondent's case in February 2017. The decision was made to revoke his license because this offense is a strong indication that he poses a financial threat to his clients and to every Texan that either accepts assistance from or pays to support government programs that involve health care. At the hearing, Mr. de la Garza insisted that he did not do anything worse than fail to properly supervise one of his employees in his billing staff. The staff member that he said was responsible for the offense was Ms. Garza, who was not related to him. And she also was not present at the hearing, either to confirm that or to refute it. But Mr. de la Garza at the hearing admitted that only he, and not Ms. Garza, could have profited from the type of theft committed in this particular case. Now, if you accept his testimony at SOA that he pled guilty when he wasn't actually guilty, that also means that he misrepresented himself to the district court by swearing under oath that he intentionally and knowingly appropriated this money and that he did so to get a better result for him and his family. And also, it's important to note that it is one of the elements of the offense of theft, that is, that it has to be done intentionally and knowingly, and not just inadvertently by a staff member. The ALJ did not accept Mr. de la Garza's explanation. The ALJ found that Mr. de la Garza committed the offense, that it could not have been committed but for his hearing instrument fitters and dispensers license, and that if he continues to hold that license, that he would have further opportunity to commit theft, even if he can't work with Medicaid money anymore. The ALJ found the respondent could commit similar thefts either through private pay or direct billing programs or through insurance fraud. The ALJ agreed the offense was directly related to the occupation and that it made him unfit to hold the license, and she was not swayed by the respondent's testimony that he has changed and that we can now trust him with a license. The department recommends that you revoke the license by adopting the proposal for decision along with the ALJ's technical revision from her exceptions letter.
All right, any questions, Mr. Sharp? All right, Mr. Hollis and Mr. de la Garza, if you do speak, make sure you fill out a form. Keep your comments to the second.
Absolutely. And again, for the record, Clay Hollis, attorney for Mr. Garza from San Antonio, Texas. Thank you, Commission, for allowing us the opportunity to address you. Special thanks to you, Commissioner Collier, for your prayer this morning, opening the proceedings. We need more of that. It was very inspiring. I want to try to summarize what went on in the hearing. I'm not going to stray from that presumably you have the record there. I want to first try to discuss and clarify what our position was with respect to the threshold issue of whether the criminal offense directly related to the purpose for which Mr. De La Garza has a license as a hearing instrument fitter and dispenser. It's not an easy issue, and there was a lot of back and forth between Mr. Thielen, myself, and Judge Frazee. Then I also want to discuss the evidence, the weight of the evidence that was produced by Mr. De La Garza at the hearing, and if I may, I have copies of the Texas Occupations Code that we followed.
Presented at the hearing?
It was presented at the hearing, yes.
Why don't you give it Tamala, that way she can go ahead and. Go ahead.
With respect to the threshold issue of whether the offense charged and pled to by Mr. De La Garza directly relates to the purpose for which he was licensed, and in the PFD, it set out pretty succinctly on page 2 that pursuant to government or Occupations Code 53.025 for hearing instrument fitters and dispensers, guidelines state that crimes against property, and we acknowledge that this was technically a crime against property, directly relate to the occupation, but for these important reasons. One, licensees interact with adults, the elderly, the disabled, and children in a provider-patient role. Persons who have a history of committing such crimes would pose a risk to the property of patients. Two, these occupations involve close proximity to and physical contact with patients and their caregivers, family, friends, and others in residences, private offices, and assisted living facilities. And three, the guidelines that the Occupations Code give is that the licensee would have access to the property of patients and their caregivers, family, friends, and others. As was discussed at the hearing, this began as, and as far as we're concerned, has always continued to be a billing issue with Medicaid. It did not involve any type of theft, overreaching, fraud with respect to patients, individual patients. It was the government. It was a billing issue, and the point I was making and continue to make is the billing of a business, whether it's a hearing aid dispenser or a law firm, for that matter. Billing can be contracted out, it can be farmed out, you don't need a license to do billing. So because this was a billing issue, it did not directly relate to the things that a licensed fitter and dispenser does. The testing of the ears, the decision of which hearing aid best suits a particular patient given the test results. That's what you need to have a license for, to do those things, not billing. So that is the spirit of that this crime, the offense, did not directly relate. The ALJ disagreed with that, and
But to confirm right quick, Ms. Garza handling the billing is an employee? Or
She
was it like-
she was an employee, and I believe, and this did come out at the hearing, she too was indicted and charged with the same offense.
Okay, I just wanted to confirm she was an employee. Thank you so much.
She was an employee.
Mhm.
The evidence at the hearing, and this is where I go to the handout that I gave you, Section 53.023, additional factors for the licensing authority to consider under subsection A in determining the fitness. And again, that is effectively the overriding conclusion of the ALJ
and the purpose for the PFD to revoke was that Mr. De La Garza is unfit. He's untrustworthy. Those are moral judgments to a man's character. State put on one witness, an investigator, young investigator named Alex Ortiz. And what he testified to and confirmed on cross-examination was, what did you do? What did your investigation consist of? He gathered the court documents that were available, looked at them, and he made the determination that Mr. De La Garza was unfit, untrustworthy, unworthy of retaining a license. I asked Mr. Ortiz, did you interview any patients? No. Did you interview the prosecutor? No. Did you interview anyone connected with the business operation and the charges that were being levied against Mr. De La Garza? And the answer was no. I got the documents that were available through the court, looked at them, and made the determination, yeah, he is not fit.
Actually, that wouldn't be true. Mr. Ortiz didn't testify that he made the determination. If he testified to anything, he would have testified that the attorneys make the determination. Investigators don't do anything but just gather documents and gather information and provide it to us. We make the determination. The investigators will be the first to tell you that. They don't want to make that determination.
In all fairness, Mr. Sharp was not at the hearing. Mr. Ortiz rendered an opinion, and I raised an objection to the judge, that Mr. De La Garza's character was untrustworthy, unfit. He made that decision.
Okay, he may have made that opinion at the court.
Yes.
But if he was offered to make that opinion at the court, that's fine. But he didn't make that opinion on behalf of the department for our decision to be made.
Okay.
So I just wanted to clarify that. Thank you.
So in the PFD, particularly number 9 in the conclusions of law, that Mr. De La Garza failed to demonstrate that he is currently fit to hold a license. That's why we go to the other factors that the Texas legislature tells us that we need to look at. And I want to go through those one by one. But it was, and even in the PFD, it's axiomatic that the legal standard here is preponderance of the evidence. And that's why I want to discuss the weight of the evidence. This is not, and I brought this up at the hearing, this is not a strict, what we call strict liability case in tort. Whereas if you commit the offense, then there are no defenses. Preponderance of the evidence is different, and particularly when you have the guidelines that the legislature puts forth. And let's to determine whether or not someone is fit to continue to be licensed, to discharge the duties and responsibilities of the occupation. A1.
If you don't have to read these to us. If
Okay.
there's one you want to point out in particular, if
Well,
that's okay with the commission,
I think they're all important because that was the great weight of the evidence produced at the hearing. No criminal past, no criminal future, an immaculate record. He was 53 at the time, and by the way, this was also discussed at the hearing through Mr. De La Garza's testimony. From the inception, this was always a matter of an issue of restitution to the state. And when these charges came down, there was actually a meeting set between Mr. De La Garza's attorney at the time and the AG's office to discuss what the amount of restitution would be. There had been some back and forth.
Is this the record, Mr. Sharp?
I'm looking for that now. The thing that I'm seeing in the PFD, this.
Okay.
And before that meeting took place, the indictment came down. So this thing went from a civil penalty restitution matter to all of a sudden it's a criminal matter. And I think that's important to keep in mind. Going back to the factors that the legislature tells us that we must consider when determining a man's character and whether he's fit. no criminal activity, no prior crimes. The conduct and the work activity of the person before the criminal activity, before getting into this business with his wife, he was an educator. He taught physics and math in Brownsville, Texas, where his permanent residence is, before joining his wife in this business. With respect to the evidence of the person's fitness, letters from all of his probation officers.
This was at the SOHO hearing.
At the SOHO hearing, he's current. In fact, we had about a 3-hour hearing. It was lengthy. That on the restitution aspect of the sentence and the judgment, and this is all here, Mr. De La Garza is actually ahead of schedule. He has 10 years to pay this fine. If everything goes as anticipated, he will have completed the restitution in 3 years, eligible at the beginning of 2020 for an early release. So he has been stellar in his performance under his requirements for restitution, well ahead of schedule.
Okay.
He's going to do in 3 years what he's given 10 years to do.
Is that accurate, Mr. Sharp? You looking?
I don't know about that part.
Was it?
I can't find it in
Again,
here, but.
go ahead.
Yeah, and I can't go out the record. I know what his current balance is.
Okay.
I can tell you if you're interested.
Yeah, no.
I mean, but the hearing was 7 months ago, so he has continued to be ahead of schedule. I think what I really want to address, though, when it comes to this man's character and whether he is fit to continue in this business and in this trade, is if you look at subpart C of 53023, has he maintained a record of steady employment? Absolutely. From the time that he was an educator in Brownsville through today, he is the man that has to do the job. And do you know why? When you look at 2, supporting the applicant's dependents, and this is in the record, his wife has terminal cystic fibrosis.
We got the record. You don't have to.
She cannot work.
Okay.
He has to do it. He is the proud father of a daughter who is graduating from Southwest on the dean's list. Kudos to her. She hopes to go to law school. Who's going to pay for that? Dad will, of course. So has he maintained a record of good conduct in your file materials? He has donated, from a humanitarian standpoint, hearing aid devices down into impoverished areas of Mexico, specifically the state of Quintana Roo. There are letters from people who are in charge of receiving that and dispensing that. So the record was replete with Mr. De La Garza being ahead of schedule, being a humanitarian by giving to the poor and the impoverished, taking care of his wife. This is also in the record. His mother has advanced Alzheimer's. He goes down to Brownsville every week to be with her because there's no one else.
And if I may, I can't recall, I'm looking for, were there any, Mr. Sharp, were there any recommendation letters, anything presented, even from his?
Actually, he alluded to him earlier.
Oh, did he allude to? So sorry about that. This
From
was,
the, yes,
but I-
Commissioner,
Right.
from the probation officers being current, the folks down in Quintana Roo talking about what Mr. De La Garza and his company has done to help with providing those.
And what about the time when he was a teacher?
Did not have anything from when he was a teacher. We focused on his time. The last, Commissioner, the last letter of recommendation, I want to read it because to me, this speaks volumes. It's from Jim and Margaret Self, 2 of Mr. De La Garza's clients in San Antonio for over 10 years. This was admitted at the hearing. Mr. Self and Ms. Self are 93 and 88 respectively. To whom it may concern, it's dated July 18th, 2018. It's part of the record. Please accept this letter as our very earnest request that Eduardo De La Garza be allowed to retain his license with the state of Texas. For over 10 years, Mr. De La Garza has assisted us in dealing with our hearing loss. During the time we have known him, we have found him to be very professional, honest, knowledgeable in his trade, kind, and courteous. His recommendations and advice have been of great benefit to us in our advanced years, and we hear similar remarks from other clients who work with him. As seniors, more than any other time in our lives, we find it so necessary to work with those who have the attributes we have noted. In addition, honesty, integrity, and trustworthiness are imperative in any business dealings. We find Eduardo De La Garza to possess all of these fine character traits. Therefore, we are asking again, most sincerely and hopefully, that he be allowed to maintain his license. We need him. That's the type of letter of recommendation that you get from Mr. De La Garza, because he is a devoted professional, he is a devoted husband, he is a devoted son, he is a devoted father. You have this billing issue, which is the only roadblock or speed bump in his path. Otherwise, it's immaculate. You would have it if it were otherwise, and you don't. We are asking, let him continue on this path. Do not do revocation if you want to look at something other than short of revocation. Willing to do that. He's willing to answer any questions you may have. We think revocation is too harsh a penalty for this offense, particularly given his track record on where he's been and how soon he will complete these guidelines. He cannot even do Medicaid patients and doesn't do Medicaid patients anymore by order of the court. He is not in a position where this can happen again, which is one of the issues in the PFD. Thank you.
Thank you, thank you. Good. Any questions?
When did you start your hearing aid practice? What year?
Good afternoon, 2009.
State your name.
I'm Luis Eduardo La Garza. I'm sorry. It was in 2009.
Okay, because I'm seeing here that you got your license in August of 2010.
Yes, well, you get, what is it called? The temporary,
Okay.
I remember the proper name.
Because the only thing being in healthcare, I've seen a lot of this. And to me, it's not a billing issue, okay? Because of his license is the reason that he gets to submit those claims, okay? He signs off on those claims. Whether it's the clerk does that or not, that's still his responsibility for it. And until, and you saying he hadn't had anything since, well, yeah, when you get caught, that's fairly serious. And the fact that he can't do any more Medicaid is only one aspect of it. He still can bill insurance, for private pay insurance or any other services that he does. And to me, from what I've seen in my profession, this was major serious offense, because again, he was the one receiving the money, for it, whether he knew what it was, but he had to code all the lines on Medicaid, and, there's ways that people used to find. They've actually changed that now, which is good. But you could find 15 different ways to bill for a procedure or a product or something else, to where you could add this for a little bit extra, you could add this for a little bit extra. And that, to me, is the seriousness of the crime. And as long as he keeps the practice, he still has that opportunity. He hadn't done it, or at least we'll say he hadn't been caught if he has done it, but I don't think he has, because that's a fairly serious criminal offense, when the feds and the state came after for that restitution. So I don't know, I'm having a really hard time, at least taking a year off, and see, what happens at that point. But I don't know, I mean, to me it was, you said it wasn't their money, You know, you said that earlier. Well, yes, it was. Okay, it was their money under Medicaid that they fell into. Okay, so I don't appreciate the fact saying, well, it was just the government money and it really wasn't anything serious, because it was.
Well, and the spirit of the comment, not that it wasn't a serious issue, but it wasn't that Mr. De La Garza did not take advantage of a patient in a way that could be manipulated, misdiagnosing, something along those lines.
You know, we're making a global comment on that. We don't know for sure. I'm sure there's different codes in the diagnosis depending on hearing loss or whatever, that you put this code in here, you get another $300, you know, for the deal. If you put this code, which could probably fall under that, you might only get $150, you know. So I don't like trying to gauge this based on a dollar amount or a billing problem. It's a treatment, you know. It's a treatment to a patient, you know, and I don't know. Like I said, that's my two cents.
Any other comments? Thank you.
Mr. Chairman, I have a couple of things that I think might help clarify a few of the statements that were made, if you think it might help you. First of all, those guidelines that we've developed and that you folks look at carefully and pass after we talk about those things ad nauseum, they're not all-inclusive. It's not possible for them ever to be all-inclusive. It's a list that contains examples of what could happen. If we were to try to put everything in there and for every single reason in there, we would have volumes of these just for one occupation. So those things that are in there, they're guidelines, they're examples. They don't mean that anything that might conceivably not be stated in here doesn't apply. I wanted to say, too, that Mr. De La Garza, he's here. He's representing some things to you today and hoping for a favorable result as he's asked. He did the same thing at district court. He said, well, I plead guilty so I can get a favorable court there. And that was, in fact, his testimony at the hearing. He also had said that, or he said that he left the teaching profession so that he could become a partner or a business associate with his wife in the hearing instrument fitters and dispensers business. But although that sounds voluntary, I don't think it was as voluntary as it suggests, because his teaching certificate was suspended for 10 years. And so he had no choice but to leave the teaching profession and do something else.
And if I can address that was in the aftermath. Not only did TDLR come after Mr. De La Garza after his plea, so did TEA. So that was well after the fact.
I don't know that was. I don't know. All I saw was in the PFD where the ALJ made reference.
The paperwork is in there. It is well after the fact.
But when did he leave the teaching profession?
Well, I think the evidence showed that it was right about the time he went to the hearing instrument fitters and dispensers business with his wife.
But the 10-year suspension would have been after all of this surfaced.
I don't know about that. Mr. Hollis might know more about that.
Absolutely. And in fact, it came after we were already dealing with the TDLR administrative matters when TEA jumped on board too. And because Mr. De La Garza doesn't have a present intention to go back into teaching, at least in the public school system, he went ahead and worked out a deal with TEA. He didn't contest. So I don't want this commission to feel that he had done something amiss as a teacher, and that's just not the case. This came in conjunction with and after these charges.
If my math is correct, it would have been November 18th of 2016 when the teacher's certificate was suspended, because that's 10 years before the end date of the suspension.
And I have the document. We can confirm the date. It was suspended retroactive to the date of the plea.
Okay.
And then finally, of course, I think everybody thinks it's commendable that Mr. De La Garza would make donations of equipment and his services in Mexico. I mean, that's terrific. It's commendable that he's going to have a daughter who goes to law school. I mean, that's terrific also. She may not think that way in 20 years, but for now, I think it's terrific. But funding those things at the expense of taxpayers, at the expense of Texans and all U.S. taxpayers, and then also at the expense of those people who need those programs and could have those services provided to them legitimately, but may not because there's not enough money around. We all know that money is a resource that's just not endless, even though some of our congressional people think it is. Sometimes these programs can't service everybody they want to service because that money's just not there. Well, if it's not there because somebody's taking it to use it somewhere else for some other commendable purpose in some other country, that's not fair to American taxpayers or to those people who could use those programs and services. And that's why TDLR thinks this is especially a case that's especially suitable for a revocation. Thank you.
Can I,
All right.
can I make a point on that? Most of the hearing aids that were donated were actually donations to us from the manufacturers, that they have all hearing aids. We asked for them, we got them, and we were able to place them there, okay? So this thing about the taxpayers, respectfully, I disagree with you.
Okay. Any other comments? All right, then I will entertain a motion.
I'm gonna make a motion.
To accept the PFD as written?
PFD
Do
is
you
written,
want to make any of the,
unless we need some amendments to
I
something.
think there might be, based on general counsel's recommendations. Maybe
Mr.
Brad?
Weston, this is Brian Francis. Could you get closer to the microphone for us?
Yes, sir. No, I said there might be some recommendations, some housekeeping rules.
Okay.
Brad, on that, if we're going to adopt the PFD as written?
Mr. Chairman, I think the ALJ may have responded to exceptions with some, I think that's what we're
Right.
referencing there. So the final recommendation from
Right.
the ALJ,
Right.
including
The
any,
exceptions.
yeah.
Correct. I mean, that's all I was
Is that
just
your
trying to
motion?
clarify.
Yeah. For the exception.
Okay.
Okay, is there a second on that motion?
Second.
Okay, discussion.
I want to say, it's great that you're making, and you're so far ahead in restitution payments. However, I'm inclined to echo Commissioner Weston's thoughts that as a business owner, the number one thing you look for is the money and the money that comes in your bank account and how you actually make money. And if that's not your number one concern, then there's no reason to be a business owner. Yes, you do it for the job that you love, that you like, to help out the people you want to help out. At the end of the day, you need to make a living, and like the PFD says, you're supporting so many people. Now, I don't know, my line of work deals with financial statements, and I don't know how much money the business makes, but you would probably clearly be able to see that extra 100,000, or even if the PFD suggested 40,000, only 40,000 that your staff found within that 2-year period, 3-year period. So like you said, Mr. Hollis, billing can be contracted out. With something so simple as billing, like you said, if it can be contracted out for $10, $15 an hour, then we should have done that from the beginning, rather than have your billing specialist doing what she did. And not being aware of that issue, I think is and that's what I don't think, I believe that you weren't aware of that.
You can apply in another year, and I would think there's somebody in the industry that you could work under their license, okay, and get paid, to do something, until you get the opportunity to reapply for that license.
1 year from the date of revocation.
Is that correct, Brad?
It would be a 1 year, yes, that's correct. It'd be a 1 year time period before he could reapply.
No chance
Yes,
of-
from the date that, I'm sorry, from the date the revocation becomes final. So there would be some, once your order becomes final, if that's what the commission ends up doing, that 1 year would start at that point.
Any comments, anything else? All right. There's been a motion and seconded. All in favor, say aye.
Aye.
Opposed? All right, motion carries. You have other options, Mr. De La Garza? Our enforcement division or staff will get with you on that, what the other options are.
Thank you.
All right, those are cases, guys. We made it through the cases. All right, now we're on to, does anybody need a break?
Probably.
All right, let's take a 3-minute, and I mean 3-minute break, so no chit-chatting.
Yes, Dad.
3
Yes,
minutes,
Dad.
don't be dilly-dally. home, so they still have a quorum. We're going to go to item J, which is hearing fitters instrument, fitters and dispensers program.
Hi, I'm Wendy Pello, Wendy Pello, Assistant General Counsel. These are the proposed rules regarding the hearing instrument fitter and dispenser practice program, and specifically rules 112.50, 112.52, and 112.53 regarding the temporary training permit holders. These proposed rules are necessary to implement House Bill 4007 from the last legislative session and to make some cleanup changes. The last session, House Bill 4007 removed some barriers and made some updated provisions in Occupations Code Chapter 402 regarding the temporary training permit holders. And so these proposed rules would allow a person to obtain a second temporary training permit if they needed to be able to complete the required education and exam. And then it also sets out requirements and limits regarding that second permit. The proposed rules also make cleanup changes regarding the criminal history background checks, and then remove a requirement that the supervisor and permit holders submit their supervised hour form and having it be notarized. So those are kind of the overview. The rules were developed with the licensing work group of the Hearing Instrument Fitters and Dispensers Advisory Board and staff, and they were recommended by the full advisory board for publication in the Texas Register for public comment. The proposed rules were published in the Texas Register on October 26, 2018 for a 30-day public comment period that ended November 26, 2018. The department received one public comment from the Texas Hearing Aid Association, who supported the proposed rules. The advisory board came back on February 7th, 2019 to discuss the proposed rules in the public comment, and they recommended to the commission that the commission adopt the proposed rules. And the department is also making a recommendation that the commission adopt the proposed rules with an effective date of May 1st, 2019. And I can answer any questions.
Any questions for Wendy? All right, I entertain a motion.
I move that we adopt the proposed rules for, what are we doing? For the.
Hearing instrument
Thank you
fitters
so
and
much.
dispensers,
We're
and the
good.
temporary training permit holders.
Is there a second?
Second.
Thank you.
All in favor, say aye.
Aye.
Opposed?
Thank you.
Thanks.
Derek. All right, midwives. Item K on the agenda.
Thanks.
Good afternoon, Commissioners. My name is Derek Burkhalter. I'm the Assistant General Counsel for TDLR. This agenda item concerns proposed amendments to the midwives' rules.
You can take these.
They implement two bills passed in the last legislative session. The first one concerning the legal liability of a midwife who is unable to administer prophylaxis to a newborn's eyes due to objection by a parent or guardian. And the second bill relates to the requirement for the department to post a list of licensed midwives on its website. The proposed amendments also implement numerous recommendations by advisory board members and department staff relating to when a midwife must coordinate care with or transfer care to other healthcare professionals, when a midwife must terminate the midwife-client relationship and how they must do so, and other general standards of conduct applicable to midwives. The proposed rules were presented to the advisory board in the fall. They recommended publication. The proposed rules were published in the Texas Register on September 28th, 2018, and the public comment period closed on October 29th. The department received 26 comments. The proposals that received the greatest number of critical comments were the changes made, first of all, to Section 115.115E6, relating to the requirement for a midwife to initiate emergency transfer when certain abnormal conditions are observed during fetal and uterine monitoring. There were 26 comments critical of that provision. The second was Section 115.114D, relating to the requirement for a midwife with a client who has reached 42.0 weeks gestation to either collaborate with or initiate transfer to a physician. And thirdly, Section 115.114C8, relating to the requirements for a midwife to recommend transfer if the client has had certain previous uterine surgeries. A standard of care work group met on November 29th and December 11th to consider the public comments and to recommend changes in response to those comments. They did recommend several changes in response to most, but not all of them. The Midwives Advisory Board met on January 8th to discuss the proposed rules, the public comments, and the work group's suggested changes based on those comments. The advisory board at that meeting voted in favor of recommending the adoption of the proposed rules with the suggested changes to sections 115.1, 115.100, and 115.111 through 115. Those changes are indicated in your meeting materials with double underlined and double stricken through text to differentiate them from the initial proposed rules that were published in the register. Our recommendation to you today is to adopt the proposed rules with the changes recommended by the board and that they be effective on May 1st, 2019. And I'm ready to answer any questions you may have.
Thank you, Derek. Any comments?
You know, I don't know how you want to propose to proceed on this. I found this rather confusing to just do it in block. I don't know how you're thinking of how you want to propose to go forward on this.
My idea is to simply, it is, because I think there's a lot of technical applications here, right, that we're going to defer to the advisory committee on this, which we can't be experts in everything, right?
Right.
Right.
And so our job is to make sure that the industry experts understand and an abundance of caution. And I made that comment several times too, as we were going through this. I'd rather err on the side of caution on any one of these. So, and I respect, and I don't feel like I don't know yourself, but incapable of contradicting on a medical side. And we lost our doctor. So, but in that regard, I mean, we have many licenses or industries under our care, but this one in particular, it touches us in a way that no other, in my opinion. And so I think that's important as we went through this. And I know that the staff went through extreme amount of care in that regard. And I want to make sure that we are giving that latitude for them to do their job, but, because there needs to be changes and modifications. So my intent, unless otherwise convinced otherwise, which can be, is to adopt them in blocks and make sure that we hear from the industry experts and the industry practitioners. So,
Mr. Chairman?
Yes, sir.
May I just add something about, Derek did a great job of laying out the rulemaking process and the recommended changes. I just wanted to add that prior to kind of beginning the rulemaking process, there was a months-long process of working with the work group, the standard of care work group for the advisory board. Some of the members are here today, and with staff working very closely with them to work on the draft and many iterations of that and many discussions, in-depth discussions about these issues. So the rule package you have before you is kind of a culmination of not just the formal rulemaking process, but a months-long in-depth look at these rules.
Right.
I guess what concerned me was, well, I'm not a huge fan of technology, but let's face it, it's not going away. One of the comments that it seemed prevalent to me throughout all of it was the insistent that that a lot of people didn't want to lose that freedom of being able to have their midwife, of not having to have the midwife be required to reach out to a physician or there was
Licensed healthcare
licensed
professional.
healthcare. Thank you. I know there was some back and forth about the language, what they wanted to use it as. And I'm like, you know, I'm sorry, we've moved forward on technology and we're going to have to be held to that standard. And, you know, the patient still has the right to reject all the way up to no matter, you know, all the way up to the end, whether they want to go or not. They still have full right and control of their body. They just should be entitled to make that choice all the way to the end. And so that was my concern, is making sure that we are still giving the patient the decision to make those choices with all technology available to them. Because there was some issue about the fetal heart and the technology, whether they're going to be able to have access to that. And we should be able, I think we should be able to make sure that those women are, have that accessibility to it.
I may be able to address that. The specific section you're referring to is, just one second. Well, of course, now I'm not going to be able to find it.
Talking about the fetal heart rate monitoring
Correct.
issue.
And I understand there are some people that are very anti it, and they want to, you know, have the choice to say, you know, that you can still, you know, still deliver the baby safely without it, and it isn't valid. And that woman still has that right to say no, but I think to not require that option to be available for all women to have that choice to say yes or no with it is a bigger stop. And so I just want to make sure that we're preserving that right.
With regard to the fetal heart rate, the initial proposed language, the comments that were received critical to that, basically the midwives felt that the new rule would require them to have advanced equipment as is used in the hospital for continuous heart rate monitoring. We altered that language to make it to where that was not the case, to where that equipment would not be required. So that was one of the changes the work group made and the advisory board recommended.
See, and that's where I'm having a problem, because even though we may not like technology, it's not leaving. And so, and we need to take advantage of having that technology. And I do have an issue that we're not going to make that technology
Available as a choice.
exactly.
Mhm.
Exactly.
Mr. Chairman?
Yes, sir.
We have two of the members of the advisory board and advisory board work group that are midwives that may be able to add some texture to the conversation and help out. Is that okay to bring them up, and we'll have them fill out a card if they have not already? Mr. Chairman, I'm deferring to you on that.
Yeah, this, again, I don't want to get granular in this thing. Okay, so if there was an issue, I'll hear it, but I want to make sure that we want to proceed.
Yes, sir.
Okay, and if we want to make that exemption or relook at it, we don't have to have the perfect answer. So, but we need to make sure. But I'd be happy if one of
I
us.
think Ms. Fremgen would probably be.
Good afternoon. I'm Lori Fremgen. I'm on the Midwives Advisory Board, and I was the chair of this work group that put the rules together. And I think to clarify what we did with regards to what you're concerned about, we took a national standard of when a midwife can move from, or should move from, that intermittent auscultation, which is how all midwives monitor babies and women in labor, and when it's recommended to move to the more advanced forms of monitoring, like the electronic fetal monitoring. So we use those national guidelines written in the rules to spell it out and make it a little bit more clear about when we should transfer. Does that
Not really.
help? No.
It doesn't explain why we wouldn't take advantage of the technology.
So let me.
At home?
Correct.
So let me do, we have great resources on our commission.
Right.
Dr. Callis.
Right.
And they're both gone.
I know.
I know. That's it. Is there a way, Brad, that we can proceed? Because I think this, I agree that we need to look at this, and I understand Commissioner Yurko's point on this, and so is there a way we can proceed with this and allow that expertise to come back and display? Is there some way, because I would really love to depend on their two insights.
So unfortunately, we are kind of at very near the end of our timeline on this particular rulemaking. So we have 6 months, once we propose a rule, to finally adopt it, or else it expires or is withdrawn automatically.
Right.
And so we're almost to the end. The end of this month is the end of that period. So it would, if we wanted to take more time with the rules, we would have to start all over from the beginning of the rulemaking process. And I don't know if that's what you're
I know, but
thinking,
see-
or if there's other,
Brad, this is Brian. I think what I'm hearing the chairman say is if there's a way to pull out this piece that's creating the discomfort here, then, and go with the rest of the rules, then move on, do it that way. I don't think we have to stop the whole process, the
Right.
whole baby,
Right.
however it's said. I was trying to create a metaphor. And Mr. Chairman, I think what may be instructive and helpful is if we move forward today with the portions that are not, controversial or bringing concerns, and those other pieces that need to be discussed, that we create an opportunity with the midwife advisory work group and a subgroup of the commissioners, Commissioner Yurko, Dr. Wesson, Dr. Callis, to listen in on that conversation, because there's more that can be said in those meetings in between than can be said at 10 minutes at the table or 5 minutes at the table. And I know there are other members of the work group that could also add value, but if we can preserve that conversation, extended conversation for a subsequent work group meeting, I think that would help.
Can I add one more thing?
Yes, ma'am.
I'm sorry. I'd like to say that this topic was discussed at great length between 3 midwives and the physician that are on our board. And,
And was that at the January meeting, or was it last year?
that's in the work group meetings.
Mhm.
Yeah, so that's where most of these
Sure.
details are kind of worked out. There is no evidence to support that more monitoring makes it safer. There's actually evidence to support the opposite, that more evidence leads to more intervention. And so, so midwives, we work traditionally, but we also use technology. We're not opposed to it when it's appropriate and when it's necessary. Hopefully, what these rules do is clarify when to move to the next step and have more technology in the monitoring.
So, let me this is, I am not the expertise on this, and we have some amazing resources here.
Absolutely.
With Yurko and Callis and Weston. So can we, at the pace, I don't want to be hasty on this, don't get me wrong, but, I hate to reset, I knew there was a timeline that we're up against. Can we section this out, get that subgroup? Are you okay, are you comfortable with that, addressing this?
We're going to have to section out, because I have learned in the past, if we don't, it will never get fixed.
No, I promise you,
Yeah,
I
I know.
promise you, I give my word.
But I have learned, if we say we're going to do it and then we'll refer it to work group, I'm still waiting 10 years now, and we've never fixed a major issue with breeders. That I was told, we're up against the deadline, if you'll just pass it, I promise we'll address it, and we never have. So,
In the modification of those rules, that's more than applicable after this. Is that accurate, right?
I'm not sure I understand.
The ability to adjust this section, is that appropriate? Is there any issue with that after if we pass this?
Right, you could open another rulemaking to address that section. So I think what, the section at issue, or the portion at issue, is 115.115, labor and delivery.
Right.
The current language is, there's a list of conditions, a non-reassuring fetal heart rate pattern, that's the current language. So what I'm understanding is you would leave that language as it is, and not adopt the changes to the rule that are proposed here, and then come back later in a subsequent rulemaking and address that particular issue.
see, what I worry about, Brad, is it's no different than if we do the same thing as we say, we pass it, and then we'll refer it back and address it. And I'm afraid if we just excise a part of it, we're doing the same thing, and it'll never get addressed. And this is really the only time we can get the attention to actually get the issues addressed properly and actually get it resolved and passed correctly the first time.
Sure.
That's my problem, that's my concern. I'm afraid if we excise it out, it's not gonna be any different than saying, we'll address it in work group, and present it to the advisory board in the future.
I think if we excise it out and leave it as the current language, there will be a lot of interest to address that issue. I'm not
But
trying to
see-
think of another way to approach it.
But see, then you're just leaving it, then basically that portion of the board who didn't want it to change anyways will be satisfied with it the way it is, and there's still no incentive to change it. So I just don't see how anything gets accomplished any differently if we vote on part of it. I just don't see it.
And I'll just offer this. The impasse that you are speaking about, it's not here. These rules came to this commission because of comments made by this commission on the informed choice process. This is a perfect example of the commission had a discussion and concerns, the advisory board worked through that, and this body of information is coming back to you as a proposal in response to those concerns. I think they're going to be just as diligent in saying, okay, here's 95% of it got done, and we've been asked to look at the this important piece which talks about the handoff and when things should escalate to that level. They're going to be just as diligent. This group here, I would encourage you not to judge them by our past mistakes and the other advisory boards. This advisory board has shown that they listen to the conversations that the commission has. Even their presence here today shows that.
Okay.
And that they'll be responsive.
Do you remember the gentleman that came in over the death of his daughter?
Absolutely.
Okay, did we address those concerns in this?
Absolutely.
Yes.
We addressed their concerns because he had a concern about not having the agency at the point of licensing look at the databases for other states. We implemented his concerns.
Okay, where is it? Because I couldn't find it in there.
It's not really, it's part of the policy that's employed at the licensing level. So when an application comes in, Dee Dee's team reviews the disciplinary database for midwives. So it's
And not to
included.
mention, I think the route to the hospital is also part of the stipulation. That was one of the other
Okay.
conditions. The route to the
This is
hospital is
The
addressed in two.
transfer of care, that whole issue was,
I remember reading that.
that
was
was a
raised
big,
at
that
the
was a big
commission
part of
level.
this.
Yeah.
And there was also.
Okay, so that isn't, so what
Absolutely.
about the request for when they requested to go to the hospital and the midwife talked her out of it? How are we addressing that issue?
This set of rules deals with the best practices for defining when a transfer should take place, the collaboration between the healthcare professional, that is the midwife, and the physicians, and still saying that there is some ownership in that patient's care, even if there's a transfer until the other healthcare professional is involved. So this body, these rules are the ones that address those concerns.
Okay, because, see, the reason why, okay, then it goes back down to the one issue on the technology.
Sure.
What I didn't understand, why we didn't have kind of met in the middle and included the technology portion in it is, you can still reject whatever the findings are in the technology, but at least you have the knowledge of it as a midwife, as the patient, as a consultant you have brought in on it. That was the point. I was like, why, because you can see the future of healthcare. Let's be honest. Is it midwifery or
Yeah, midwifery.
It
yeah.
is.
Mhm. I told you.
Oh!
Continue on.
Okay, but you can see, honestly, the future of midwifery, I told my daughter this morning, I guarantee you, you're gonna be delivering with the help of a midwife in the future. And I said, and I feel like today is so important to make sure her and her peers have the best possible care by a midwife. And I wanna make sure those seeds are planted now, that it is done safely for you in the future. And that's why I think this is so important, because
Right.
I don't think your industry is a cottage industry. I think it's gonna be the future.
Yeah.
And so, and that's why I want to make sure that what is set here, it doesn't take away the choice that a woman is going to have in her delivery, and it doesn't take away the wisdom or the recommendation a midwife has, but I do think we still need to honor the consult portion of it, and that's what I didn't want to diminish. And I think part of that consult is knowledge that's aided by technology. And that's where I'm getting on, and that's what I'm not seeing right now.
On this section.
Correct.
Okay, so there's two options here, and the committee can, the commission can decide whether we can proceed with that exemption out, which, that's one, and we can go, and I'm chairing this, I will promise you all right? That we will come back at this in June, and I want, we have our next meeting in June, and I want to hear Dr. Callis personally, and Dr. West, and Commissioner Butler on this, because he's passionate as well.
Yeah.
But we do have that statute, and I hate to say that we defer this whole thing, reset the thing, because I think it'll delay it even more to update what we needed to get updated. Or we just not update it at all, and I'm okay with this. Those are the two motions.
Can I add
Is that accurate, Brad? Or am I
And
missing-
the
misspeaking?
second is to.
Or update the whole thing completely as is and
So, yeah, you have the package that's before you, you could adopt everything, or you could take out the one piece.
Or not adopt
Or you
anything.
could not adopt anything.
And-
Those are your options.
And I'm sorry, Brad, I'll defer to you on this, Brad. I thought there was a limitation on the medical professions that the commission had to adopt the rules as proposed by the advisory board without modification.
You can't, right, there is a Chapter 51 provision, Derek raises a good point, but I think you could not, you couldn't tweak or change the language here at the commission level because it's a standard of care rule, it has to be proposed through the advisory board, but you could just not adopt that particular rule, which is, I think, that would be the excise option, and send it back to the advisory board, and the commission can continue to discuss that and work on it.
it would go back to the advisory board, and they'd have to come back to us,
Yes.
which would include, so,
Mhm.
those are the three options.
And the question is, how long of a delay would that be if it's a?
Any comments?
Well, it's going to be the same.
Okay.
It's going to be
Can
the
I,
same. no
can
matter
I
what.
add one more thing? If you choose to not vote on the recommendations, it leaves the language very vague. And what we purposely tried to do was add more clarity and requirements. Honestly, it was meant to have more requirements. Also, we are a very passionate group, and if you guys have concerns, I am so happy to take it back to not only our board, but all the state midwives, all the Texas midwives, and begin a conversation about what you're proposing and what that might actually look like in our state.
If I could also add one more
For the
thing.
record, I'm in full agreement with where you're at right now. I think that where you're headed technology, I'm not on the opposite side of that, just
Yeah.
FYI, full agreement.
If I could address one more thing about the technology element. Looking at the comments, the concern about the technology was that the machinery or the technology would be cost prohibitive for midwives, and the majority of the midwives would not be able to purchase that equipment and would essentially cause them to not be able to exercise their license.
Something to consider, but not
But there's got to be a way, to bridge that, where in this sense that then you have to bring a consult in. Because if that is the issue, where you've got a situation where the heartbeat is questionable and you can't use the technology to improve it, then maybe that home delivery may not be the safest way for that mom and child.
You don't use technology to improve the heartbeat, you just use it to monitor, and we have technology that we actually use to monitor. It looks a little bit different than what they use in the hospital, but we are monitoring in exactly the same way, following the exact same standards that doctors follow, their national standards that are set forth for all practitioners.
But what are you talking about? Are you talking about stethoscopes, or are you talking about something else?
I'm talking about something else. We use them, they're called Dopplers. It's an ultrasound machine equipment. It's something that doctors use in their offices. It's also what they use in the hospital, but they have the added element of putting it on a graph. So it becomes a visual display. The only difference is we're doing it auditorily. So midwives are very trained and have specific expertise in actually interpreting in this way. So we do have the technology.
And Brian Francis speaking, there was when we held the first ever Midwife Education Summit in January, there was a section dedicated to this particular element here, and it was very, very instructive to, one, hear the presentation, to have the midwives engage in this conversation. Dr. Guillory, who is on the advisory board, was also present and part of it, but it was reaffirming the current processes and techniques, as well as the commitment to developing new standards, consistent standards for midwives across the state. But that's something that we can look at going forward. Mr. Chairman, we are looking at a July second edition of the Midwife Education Summit. It may be more appropriate to have, if we're going to pull it out, and I don't know how the commission's going to go, but if we pull this segment out, it may be more appropriate to have that conversation take place in earnest during that July segment, and we have even more thorough discussion about that. And of course, we can extend invitations to commissioners to attend that as well. John, give options.
Commissioners, I need to hear where your heart is on this one.
I'm a part of the, from the commission standpoint, oversee the this particular advisory group, so I'm on the group. So I've seen the passion, and I, believe them in their commitment, that they'll take a look at it and so forth, if it needs to, have further, review and stuff. So I believe that, because I've seen them and I've talked with them, right, as well as other midwives. I am also okay with having the doctors on the commission to be a part of that as well, if, it needs to have the assurance going here. I'm okay with that as well. But I definitely know the passion here, and if the advisory group has done due diligence and gone through it, then, but I'm an engineer.
Okay.
Yeah, I think I have to somewhat echo the same thing where I understand it's been reviewed over and over, and you guys are the experts and professionals, but we want this to pass, and I think we all got to get comfortable. So
Yeah,
I think I'd be fine with you then.
I need a motion.
So the motion would be to, I think, from the sake of the commission, to adopt the rulings, the language, but I want to pull that out and let's make sure that we review it. And I know it's not shaping as it needs to, but let's review it, take advantage of the July scenario. I think we need to do that for the commission.
And so, Commissioner, if I may, it would just be adopting the rule package with the exception of 115.115
E6.
Thank you.
Is that accurate?
I believe so.
Yeah, I'm not on that page, so. C8. Yeah, so if that's the.
115, right,
what-
labor and delivery.
Sure.
This is the section you're talking about right here, right?
Oh, there you go. I'm on the wrong, I was looking at the comments.
Section 115, labor and delivery.
What page is that?
B, or 6.
What page is that?
It's E6. yes.
E6, sorry, E6.
It begins abnormal fetal or uterine monitoring.
So the idea would to adopt it, take that out, and then send that back to the advisory board. Is that what you're saying?
That's correct. Let's just do the due diligence. Let's just do the due diligence to make it
Can we
happen,
get it
because
one
it
more
has
time?
to, this body has to be comfortable with it. And that's gonna be key, because we'll be held.
That's your motion, is there a second?
That's what I got.
Second.
All right, discussion.
You need how many to pass this? 3?
3.
Right now, right, we have vague, ambiguous regs. That's the way I understand it, right? So what we currently have, this, other than this, right, there's some specifics. I think it's important to get the weigh-in of the commissioners that are not here, and I think that's important to have that. The safety cost is not an issue, in my opinion. I would rather err on the side of caution any day of the week, so that's important in my mind. So I think that it's important we are being cautious by go ahead and making clarity and highlighting this. I understand the precedents in the past is maybe warranted concern, which I will make sure that doesn't happen, but I specifically would like to have this section out and talk to Dr. Callis and Dr. Weston on this.
Sure.
And not only that, but because I know that they're in there, so.
Sure.
I would be, so,
Yeah.
anyway, that's my 2 cents before we vote on it.
Yeah, so I know that I was before we vote, I know I was in Austin the day of, or maybe the day after they had the summit, for the Midwife Summit. Or do we have the minutes, or what do we have, Brian, coming out of that specifically around the
We have
technology?
the audio of it is available on our webpage, so you can get the full presentation. That whole summit's been captured.
Okay, but could we just get the portion that talks about, this element here? Do we have it in that manner?
We'll find it.
Okay, all right, let's look to do that, maybe have it queued up for the commissioners, so,
Okay. All right, we had a motion. Any other discussion? All those in favor, say aye.
Aye.
Opposed?
No.
Do a roll call. What?
I'm sorry, what are we, what? Yes,
call.
yes, aye.
Joel Garza,
Aye.
Commissioner Yurko,
No.
and Commissioner Figueroa.
Aye. Ayes have it, passes. Good job.
So,
No, I'm proud of you.
so I'll be at the next midwives group meeting, so let's, you and I, chat about that.
Okay.
Yeah.
All right, guys.
Great.
Thank you, guys. Hey,
All right.
thank you.
All right, thanks.
The fact that we're so intense about it makes me feel good. All right, next is on the agenda is item, I can't read, is that L or an I?
Yes, sir, L.
It's an L. I can't read it. L. The approval of appointments. We're gonna go through all of them except for, I think we're gonna take Elevator Advisory Board and Licensed Breeder Advisory Committee off.
Yes,
So, members, you have a copy of the recommendations on the board, and any questions or comments? If there's none, I'd like to entertain a motion to approve, except with excluding those two advisory boards.
Repeat that, Mr. Chairman?
Or chit-chatting, weren't you?
Yeah, we were, I'm sorry.
Okay, members, you all should have a copy of the
I
recommendations.
may have to sit by myself.
Okay, the board appointments, any
Can't sit
questions
with
or
him,
comments?
Can't sit with the attorney.
If you have any, I'd entertain a motion. We're not gonna vote on, we're gonna take out Elevator Advisory Board and Licensed Breeder Committee. Other than that, everything else is gonna be on. So, is there a motion?
Got it.
I so move.
Second? All in favor, say aye.
Aye.
Aye. Opposed? Motion carries. Pamela, can you read the names, please?
The Electrical Safety and Licensing Advisory Board appoints Joseph Mark Roach as presiding officer. It also appoints David Whitmire as a master electrician. Code Enforcement Officers Advisory Committee reappoints Richard Adams as a registered code enforcement officer. The Combative Sports Advisory Board reappoints Eric Garcia as a MMA promoter, Dr. Manuel J. Gonzalez as a doctor for the board, and Dr. Randolph Taylor is also reappointed as a doctor for the board. The Hearing Instrument Fitters and Dispensers Advisory Board reappoints Amy Trost as a hearing instrument fitter and dispenser. The Texas Tax Professional Advisory Committee reappoints John Andrew Scott as a public member. The Towing and Storage Advisory Board reappoints Tasha Mora as a tow and VSF representative. The Used Automotive Parts Recycling Advisory Board reappoints Bruce Ormond as a domestic auto parts business and Byron Farrell as a domestic auto parts business. That
That's it?
concludes.
I want to thank each of those advisory boards. They, servant's attitude, and thank them so much for agreeing to serve away from their time. All right, Brian, do you want to give your report, or you want to?
Mr. Chairman, just number one, I want to commend you. You did a great job in the chair. We ran a great meeting, and it was an interestingly high number of public comments, but it was also very good dialogue and exchange on all the cases. So kudos to you on that. Welcome aboard, Commissioner Garza. You did a good job.
Great first meeting.
He showed up and showed out. I love it. I love it. Mr. Chairman, I don't have anything to report except for, as you're aware, we're in the throes of the legislative session. Things are going to start picking up quite a bit. Next week, we already have, our Tuesday, I think there's 15 bills between two of our primary committees that we'll be providing resource testimony for. But we'll continue to keep you apprised of those during the Friday updates for the bill tracking documents. Remember that far right column shows the most recent movement from the last bill tracking. So it'll be green if there's movement from committee to the next chamber. It'll be red if it has a hearing coming up. So use that as your indicator. And if there's any questions that you have regarding the process, any bills that are out there, we stand ready to serve you.
Staff, thank you guys for what you do. Thank you for babysitting me today. I think I got my walking legs, so that's not bad. And I got my two nannies over here, so it's always good to have
HR?
I think that's, I think officially I think Joel's buying lunch being the rookie, so that's a good news. So, can I have a motion to adjourn?
I move that we adjourn.
Second.
All right, we're adjourned.